My lord, item 16, Mr. Senior Advocate Mr. Rafa is not today in accommodation, but the matter come next week. Item 16, I am from the respondent.
Mr. Rafa is for the
Respondent.
Have you taken the consent of the learning council for the petition?
You may inform. You are out of station, Mr. Rafa. Mr. Rafa, Senior.
No, we have no invitation to accommodate, but
I will inform my lord. Mr. Maharana, I will inform.
Union of India. Anybody is there?
Item 2.
Item 16, Biswajit Maharana.
Yes, I will inform. Next to the. And Mr. Ramanath Acharya.
A mention is made by Mr. Ramakanta Acharya and counsel for the respondent that the senior advocate, Mr. Jayant Kumar, is supposed to argue the matter and is out of station. Therefore, the matter may be taken up next week. Next week. We are mentioning that Mr. Biswajit Maharana.
Yes,
no objection.
Yes.
Mr. Biswajit Maharana, Learned
Senior
panel counsel has no objection. Accordingly, this matter only. Today is past, so we are fixing it on 8th of December 2020.
Yes, ma'am.
Criminal appeal, IF for illness of on the ground of illness of mother. In other words, generally jail criminal appeal 2023 crash bill.
iPhone number 9. Answer of the day after.
You are mentioning on behalf of the petitioner. What is your good name? Sandhyarani Parida. Sandhyarani Parida, Land Council for the petition of the 6th for adjournment the day after tomorrow. This matter on the 3rd of December 2020.
Item 22.
Yes.
Will matter solution.
Well, taken up next week.
File the memo. Please file.
Item 22.
Yeah.
Last minutes listed in 10/11/2025. Directed to filing the written note of submissions. My learned seniors filing written note of submissions. I pray 1 week time. I have also filing written note of submissions.
You are for the.
I am the Union of India, but
and Mr. Sahoo.
Yes.
He has already filed.
I written note of submissions and flag I, my lord. 17/11.
You want to file the.
Yes, my lord. Copy me.
So you are keeping it next week?
My lord.
Mr.
Ajay Kumar, senior pan.
N.K. Sahoo, running counsel for the opposite party, has already filed the written note of argument.
17/11.
You are for the opposite party number 5.
No, opposite, sole opposite.
Sole opposite party. But it is in the list, it is mentioned that
opposite 5.
Written submission by opposite party number 5 is at flag 1. How many opposite parties are there?
Only one.
One man.
How it is mentioned there? What I find opposite good sole opposite party is opposite party number 5 put are. You are mentioning item number 22.
Yes,
Yes, ma'am.
N.K. Sahoo is the
opposite part, sole opposite part.
Written submission by opposite party number 5 as flag 1. So that should not be 5 because there is only one of it. So it may have are you follow? Has already filed the written note of submission, and Mr. Ajay Kumar Roy and the senior panel counsel submits that it is a written note of submission to some other
15th yes.
And the matter may be taken up thereafter. In view of the submission, this matter on 15th December 2025.
I beg your pardon.
In the meantime, the same shall be placed on record and a copy of the written note of submission shall be served on the Land Council for the opposite part.
My lord, the interim order, my lord, interim protection.
There is an interim order.
Yes, contempt shall not proceed, my lord.
Yes.
Order number 21.
We have to fill out this.
Who order is now?
21 the last one. Tribunals are not to proceed the contempt petition, my lord.
Okay, the interim order dated
10/11.
10/11/2025 passed in IA number 18617 of 2025 shall continue till the next date.
I beg your pardon, my lord. Item 3 and 4, I am in virtual mode. May I pray that item 3 and 4 may be taken up some other day convenient to allotted. I am outside the state. There is no interim order in my favor. Central government has to take instruction in the matter.
Have you taken
Tomorrow or
Yes, ma'am.
tomorrow, your lordship,
the
I'll be able to assist you, lordship.
Kumar Mishra and counsel for the petitioner submits that the matter may be taken out from day after tomorrow.
No, tomorrow, your lordship. Tomorrow or Thursday?
Tomorrow it is not possible.
Thursday, your lordship.
There is some other bench on
Your
Tuesday and Thursday. There is a separate bench.
Your lordship may be taken up next week. Maybe taken up next week.
The matter is taken up.
Next week, any day come.
The Land
Oblige.
Council of India submits that as per the previous order, he has already obtained instruction in the matter. Please this matter on 8th of December 2025.
For my lord, sir.
Oblige.
काउंसिल को नाम लिखिए 8/12/2025 3 नंबर और 4 नंबर ये
Weekly Daily First Up, item number 1.
My notes. I pray for the appellant. We're filing the application for bringing on legal help of respondent number 567. My notes. Have you given copy to the other side? Mishra. I think you are the sole respondent.
No, my lord.
There are
No, other respondents there.
then why are you not having copy on them also? They have already entered appearance. He is appearing for respondent number 1, 2, perhaps 3 and 4. Mr. Nayak,
My lord.
you are appearing perhaps 1, 2, 3 and 4.
3 and 4. 5, 6,
So far as
7.
the private opposite parties are concerned,
My lord.
respondents number 5, 6 and 7.
My lord.
Who is appearing?
5, 6, 7.
They are
3 of them are
They are dead.
Just give the application. The schedule in the schedule you have written.
mad. In fact,
The first schedule is respondent number 5,
Five.
isn't it?
no.
So who is to be substituted? What is that schedule?
Schedule that's also
Acha, in place of
6.
respondent number 5. Okay.
Next 6 and 7.
6 and 7.
Mr. Chaudhary, you have to file amended memo party.
So any objection or will allow it?
Formal.
Allow. 11. This application has been filed by the appellants in court today for substitution of the deceased respondents number 5, 6 and 7. let the interim application be registered. You have not given, it should have been mentioned, IA number dash of 2025. That you have not mentioned, please correct it, okay? The copy of the interim application has been served on the Land Council for the state in court today, who after going through the interim application has no objection to the prayer made in it. Accordingly, the legal heirs of the respondents number 5 and 6 as per the schedule are permitted to
5,
be
6, 7.
5, 6 and 7.
Deceased
Respondents are permitted to be substituted in place of respondent number, the aforesaid respondent. The interim application is disposed of, stopped. Land Council for the appellant shall file a consolidated cost title. What time you require? Because notice has to go to them. 1 week will file. Within a week. So we are fixing it on 10th of December 2025. In the meantime, you file that consolidated copy amending that inserting.
Okay, that's very status code full operating time location. Status code is operating favor of the appellants.
What is
Mr. Chaudhary, you file it within 2 days, but see the status quo is order is operating. There is a Supreme Court direction. Subject to you filing within 2 days, we will.
In fact, what has transpired from the records, what I have observed, my lord, the lower court records are not.
No, that's a different story.
That is
That's
one
a different story.
Secondly, the previous order passed by the Lord says the name of respondent number 5 is wrongly recorded. So it may, my lord's name.
That those things will. No, there is no.
It has been recorded Sahoo Hon'Ble
Subject to the petitioners filing the consolidated memo of parties, issue notice to within 2 days. Issue notice to the newly added respondents. Newly added respondents. Newly substituted respondents. Then you file it in 2 days.
Can it be after next week? That is after 10th of December.
No, you file your that consolidated. How
We'll
much
file
time it?
We'll file it, but the
No,
next
hearing.
No, hearing it's
Let it be on 10th. You send because that service will be complete. They will come very one day.
File the that amended cost title. Amended cost title. The cost title. And you also take steps for them. Let it come on 10th and we'll see the progress.
The service is complete. Thereafter, for hearing, you will get in any case.
Much of it.
The service should be made by speed post with proof of delivery. Yeah.
Notice has been issued to the 567 letter of 567 will notice issued to the 567.
Obviously.
So that we can curtail time.
Within ভিতরে ফাইল করিবে কনসোলিডেটেড কস্ট টাইটেলটা তারপরে রিকুজাইটস মধ্যে ফাইল করিবে তারপরে স্পিড পোস্ট রিকুজাইটস নোটিস ହେଇଯିବ then it will come and you will see that. Yes, next.
The state to continue.
Yes, I mean,
Much of
entry in order to continue till next step. Yes.
Item 2.
Kindly look to the order dated 17/11. Last order. Order number 8. May I please? This matter is taken up through hybrid arrangement. Mr. Biswajit Maharana, on a senior panel counsel, filed a memo of appearance on behalf of the Union of India. This is taken on record. This is an application for amendment of the writ petition. The grounds have been taken in the interim application to show that the cause of action of initiating OA arose for the first time on 19th July 2022, when the promotions of juniors were given effect retrospectively, and secondly, their representations filed in various dates in the month of July 2022
against such order was not considered. And thirdly, the seniority list was published on 5th September 2022, lowering down the position of the petitioners in comparison with the juniors. And fourthly, the petitioners filed their representations during month of September 2022. And lastly, notification dated 14th October 2022 was notified rejecting the representation of the petitioners. Mr. Swapna Kumar Ojal and counsel for the petitioners pointed out that Section 21 of the Administrative Tribunal Act 1985, that since the petitioners approached the Learned Tribunal within a period of 1 year from the date of cause of action arose in the matter, dismissing the way on the ground that the petitioners are fence-sitter cannot be treated as proper reason. Learned Counsel also brought to this court that one Ajay Kumar Biswal, who also approached the Learned Tribunal against the order dated 14/10/2022 in way number such and such, was granted relief, whereas the prayer of the petitioners was turned down. Mr. Maharana, Learned Senior Panel Counsel, appearing for the Union of India, has filed the counter affidavit with the interim application for amendment of the writ petition. After going through the averments taken in the interim application and the counter affidavit, and on hearing the Learned Counsel for the respective parties, we are inclined to accept the prayer made in the interim application. The schedule of amendments shall be part of the writ petition. Accordingly, I is disposed. Then order 9, my lord, let the consolidated writ petition be filed within a period of 7 days from the date today, after serving thereof the Learned thereof on the Learned Counsel for the Union of India. List this matter after filing the consolidated writ petition under the heading fresh admission, indicating the name of Sir Biswajit Maharana, Learned Senior Panel Counsel, appearing for the Union of India in the cause list as well as at the top of the brief. The Learned Senior Panel Counsel shall obtain instruction as to whether any challenge has been made in the meantime to the order dated 24/9/2025 passed by the Learned Central Administrative Tribunal, Cuttack Bench, Cuttack, in the case of Ajay Kumar Biswal in way number such and such. That means my argument was prior and after the Learned Tribunal allowed, they got the benefit that has been accepted by the authority. Not only that, my lord, that batch of matters, they came before this honorable court, and this honorable court has already dismissed all those applications. Thereafter, they have implemented.
This date is wrongly perhaps mentioned. This last page, that should be
24/9/2025,
or it is 14/10.
No.
24/9/2025.
But order dated is 14/10/2020.
Yes.
Order that way order was passed on against the order dated so and so 14/10/2022, where the representation, your representation was rejected, so also that of Ajay Biswal.
Yes.
And challenging that the way was filed.
He filed, I filed.
His way was allowed.
Yeah.
And your way was dismissed
on the ground of
limitation. And then he is supposed to take instruction as to whether any challenge has been made, because according to you, both of you and Ajay stand on the similar foot. What is your case?
1 minute. Let us see whether Ajay Kumar Biswal has challenged.
I pray that I wouldn't get it. Because you lordship, I beg your pardon, my lord, that
ଆପଣଙ୍କ ସେଇ ଦିନ ହିଁ ଅପଲୋଡ ହଉଛି। ଆପଣ ମାନେ ଗୋଟେ କପି କରିକି ଆପଣ ଯଦି ଫାଇଲରେ ମେଣ୍ଟେନ କରନ୍ତେ ତାହେଲେ ଜାଣିପାରନ୍ତେ passed a detailed order on 17/11/2025.
petition has been allowed.
2 minutes now in computer. This thing you can get it immediately.
My instruction is matter has been referred to the CBDT for approval. Because my lord, a batch of matters this honorable court has already dismissed. Same matter, my lord. This honorable court has already
next week.
That order you have placed on record.
No, sir.
You file that also. Again he'll seek time. ଆପଣ ସେଇ ମ୍ୟାଟର ବି ଦିଅନ୍ତୁ ନା
ମୁଁ ଗୋଟେ ଦେଇ ଦଉଛି।
ଯୋଉମାନଙ୍କର ରିପ୍ରେଜେଣ୍ଟେସନ ରିଜେକ୍ଟ ହେଇଥିଲା ତାଙ୍କ ଭିତରୁ ଯଦି କିଛି ଲୋକଙ୍କୁ ଅଲରେଡି ରିଲିଫ ମିଳିକିନି ତାଙ୍କର କେସ୍ ରେକମେଣ୍ଡ ହେଇଗଲାଣି, ତ ଅନ୍ୟମାନଙ୍କର ବିଷୟରେ କିଛି ଅସୁବିଧା ହବାର କଥା ନୁହେଁ। So that is the reason if you have got that
ଏଇଟା ଦଉଛି ଯେ prior to ଆମ କେସ୍ ଛାଡିକି ଆଗରୁ ଆ ପୂର୍ବରୁ ମଧ୍ୟ batch of matters filed and that
Whatever
was allowed.
orders you are relying upon, you
Mila.
give a copy so that we seek instruction.
That cause of action, my lord, that happened arrived in arose in 2012, my lord.
It's all right now.
I just apprised you, lordship. Challenging that order, some persons has been filed the OA before the honorable tribunal, and that has been allowed. That has been assailed in by department in the High Court.
When he representation was dismissed
Not
on 14/10,
my lord,
2022. That was challenged by Ajay Biswal.
no, that is not my first cause of action when it arises.
First forget.
Limit that fast cause action.
Because
How can you
COA.
distinguish between the case of Ajay Biswal and this petition?
because
they are
my respective submission before lordship.
Yeah.
This order has not been to the notice while tribunal passed the present order. This order, which has been dismissed by the tribunal, that has not brought to the notice of the tribunal while passing the fresh order passed by the court. You also may kindly see page 115.
We are not on that. We just want to see that whether this Ajay Biswal representation along with the petitioner's representation were disposed of on 14/10/2022, and whether Ajay Biswal filed that original application in the very same year like the petitioner has filed, but his case was allowed, whereas the petitioner's case was disallowed on the ground of delay, and he has been nomenclatured as a friend sitter. So that is not correct. If
the friend sitter, that what my respect is. So this order passed by the tribunal while not taken in care while disposing the Ajay case.
friend sitter se kem diyala.
You also kindly 115 page, that will be sufficient all these things. You also may kindly
you take instruction on.
My lord.
The learned counsel for the Mr. Vishwajit Maharana, learned senior panel counsel. Takes adjournment till next week to obtain instruction as per the order dated 17/11/2025 as to whether Union of India has challenged the order dated 24/9/2025 passed by the Central Administrative Tribunal Cuttack Bench Cuttack in the case of Ajay Kumar Biswal in OA number 260/00584 of 2022. Placed this matter on 8th of December 2020.
10th वाला था
आजिकल एते इजी ହେଇଗଲାଣି कंप्यूटर
I am not there.
अजय कुमार विश्वाल जदि आपण हाई कोर्ट ये रे लगेई देबे पार्टी ना से संगे देखो माने 2 मिनिट एठी भी हमें बाहर कर आपण ता पई कहउछंती
ना मो माय पर्सनल डिफिकल्ट पर्सनल डिफिकल्ट दैट्स
अच्छा 10/12/2025 yes next
Item 5.
The applicant, the petition was before the Honorable Tribunal in OA number 173/23.
The previous order.
Yes, your lordship. The previous order, which was called in question before the tribunal, is at.
Please come to 13/11/2025. But we passed the order.
14/11.
Are you having that copy, or you see from the website? If you देखो the order ta कौन pass?
Yes.
14/11/2025 order ta बाहर.
Pursuant to that, I have already submitted.
Please place that order.
The counsel for the petition seeks for an adjournment to file the copy of the original application as well as the entire pleadings filed before the lawrence Central Administrative Tribunal.
Have you filed?
Yes, we have already filed.
Then read it. Then
the
of so and so, yes, shall be reflected. Then next.
Yes.
Yes.
While dealing with the read petitions in our assignment determination, invariably we come across when read petitions are being filed, challenge the judgment of Lawrence Central Administrative Tribunal without enclosing.
No, it's already. If you file not appeal, then we fail to touch a standing order.
Yes.
whether we felt it necessary before this one. So,
Wasting price.
अच्छा एटा कर दियंतु रजिस्ट्री किसी नोट दे कि प्लेस करती the copy of the note अच्छा अच्छा while dealing with the felt it appropriate to answer the direct accordingly steps be taken to prepare on halata पे कैसे लगेंगे यहाँ पर
Please correct.
अच्छा कोई तो भी जो order रही थी मैं तो लिखूँ as per the order dated 14/11/2025 it seems that deputy register then judicial on 28/11/2025 has placed the notes this court be intimated in writing as to whether any standing order in this regard has been issued or not. Or not. Next one, phone. Yes, what is your case?
The petitioner being agreed to the order on Annex 20 has moved this honorable court under challenge the same, freeing for his quashing. Millard,
4/4/25.
yes, 4/4/25 is input before this honorable court. Millard, in that case, the prayer of the petitioner for being given seniority along with his like the similarly placed persons have been rejected, and the grounds of the grounds of rejections have been stated in para 11 of the import order at page 84.
No, you are claiming seniority over whom?
Because I am only claiming seniority that similar three persons belonging to South East Coast Railway, they opted to be transferred to the East Coast Railway after its bifurcation, after its creation. The other two persons who were exactly similar situated like us, like this petitioner, they have been allowed, and all the three persons who are before the tribunal in two cases, their cases were allowed. In my case, that your representation is pending, that will be considered, and that was consideration was made, that was rejected, and the cases which were allowed in favor of other two persons, the Union of India came to High Court, and High Court dismissed the writ petitions. Pursuant to that, their orders were implemented. They were allowed seniority from the date of the exercise of the option. But in my case, that is not being allowed. I have been all along pursuing the matter. We are exactly similar situated. At that point was also raised before the tribunal. That point has never been dealt with. I have been discriminated. The other two persons and those orders, these applications of Union of India, which have been dismissed by this honorable court, have been annexed under Annex 12 and 13. And these two persons were before the tribunal under Annex 9 series. Their way were allowed. And this person, 424 by mirror 424 by 09, 425 by 09. These two cases are filed by similarly placed persons. My case is 426 by 09. These two cases were allowed by the tribunal, and against that order they came to High Court. High Court dismissed the writ petitions. Pursuant to that, they have implemented the order. They have given the seniority. And these three persons, while working in the South East Coast Railway, that division was bifurcated. And ultimately, they were allowed to exercise option whether they intend to continue in the present division or they intend to transfer to the new division. They exercised their options, and their options are allowed by the railway board and by the same order. But this person is being discriminated.
For whom you want to claim your seniority? Let us say if you claim seniority over ABC.
Milord, I have said in Annexure 8 at page 40, I have shown instances, 3 persons who have come to the grade of group B later on in subsequent period after my promotion to group B, they have been placed above me in the
Mr. Counsel, that is why we are placing, you are claiming that you should be placed senior
in appropriate place.
Senior to agency, or let us say XYZ. Are not they supposed to be implemented as parties in the tribunal?
Milord, in subsequent in tribunal, I had made them parties.
Where is that?
Yes, your lordship can see.
You see, come to the cause title.
Milord, but in this round of litigations, I had not.
How can we release the grant?
But in previous case, those persons.
No question of previous case. If you are claiming your seniority over XYZ, they have a right to be heard, or without hearing them, the London Tribunal will straight away place you above them.
I am in respectful agreement with the lordships.
Then why, if you have not made a party, how that prayer can be entertained either by the tribunal or by us?
On that score, the case has not been rejected.
Whatever we are putting your legal question.
Your lordship is right in saying so.
Then,
because in the previous OA, the petition has filed original applications before the tribunal in all the cases except the last one. He has not made them parties. But in other cases, they have made them parties. They have never responded.
So in some cases, you have made them parties earlier. That is why you think it proper that in this case, where similar prayer is made, they need not be added as party. That
in the first round, you file AOA,
yes,
making them party.
Yes, Miller.
The tribunal says that you give representation, they will consider.
Yes, sir.
And the representation was considered and rejected. Thereafter, you file OA again.
Yes.
In that OA, you don't make the party.
Miller, in annexure 10, that is my OA 426/09. In that case, OP number
That's
6,
right. There you have done it. But subsequently, where this order is passed, it is obligatory on your part. It suffers from misjudged of party.
They are necessary parties. How can you say no to that? Are they not necessary parties? Suppose you would have been placed in their position, and XYZ, any of the XYZ would have made similar prayer, and if your contention is accepted, that his prayer would have been allowed without even knowing that their prayer is allowed, and subsequently one order would be passed that
these persons have retired since long. These persons
their seniority is effective.
Long. And their seniority is not going to be affected. And other persons.
Have you said that in the tribunal? Have you said that in the tribunal in the way? I am not making them party because they already demitted office, so their seniority will not affected. They will not be affected.
That point was not raised by the the central council. The points on which I place the matter before the tribunal that this person being similarly situated like other two persons should be treated equally. But that aspect has never been dealt with and dealt with in the input order. When I am particularly saying they belong to same class, they opted the exercise the option to go to the newly created division, but they have been allowed. And in my case, this petition is been discriminated. And your lordship can see
Reddy and Naik.
Reddy and Naik. In that case, in the input order, not a single word is whispered about that aspect, whether discrimination is being caused to this petition or not. Nothing is being said nothing has been said in the input order.
See
that aspect.
First paragraph in order. First paragraph in the order. Second
paragraph.
Reddy and
GS Reddy and Rajendra Naik. Whether this GS Reddy and Rajendra Naik have died in the meantime, retired.
Yes, Mrs. I have information they have retired.
Make a specific.
They have retired. They have retired.
No, you should. You see, once we are making a query, we must clarify while issuing notice to that. That they will no way be affected in.
Milord, they have retired.
You have not been made them party. Now you are taking a stand that you are not claiming any relief against those two persons.
Yes, Milord.
So because they have already retired,
yes, Milord.
That must be brought on record, not by oral submission, but by way of an affidavit.
I will do so, Milord. I may be permitted sometime.
Learned counsel for the petitioner submits that the necessary parties to the OA who have not been implemented have already demitted office. Therefore, they are not being affected by the said order. This part of the submission is not reflecting in the entire pleading before us. Therefore, learned counsel for the petitioner seeks time to file an affidavit to that effect.
Put up this matter on Quebec
After 2 weeks.
after 2 weeks. 15th or any other
15th,
date?
15th, 15th. Obliged.
The presence make the one of State Union of India. Yes.
Item 6.
You know, in this case, as per your lordship's previous direction, I have submitted all the pleadings of the OA, counter, rejoinder, etc., everything before lordship.
What is your relief?
You know, in that case, the prayer of the applicant, the petitioner made a file one miscase seeking amendment of the OA to bring on record some documents which are very much relevant for adjudication of the dispute.
No, impugned order is 3725.
25, that is the final gradation list.
Please come to that order. Please come to that miscellaneous application order.
Annexure 7 is
Annexure 7
is
order. That was passed on 3725,
Yes.
right?
Yes, my lord.
Please come to that. That is page number 60.
60. The counsel for the applicant submitted that he has filed MA number 103/25 praying for amendment in a way. He submitted that the applicant wants to incorporate the final gradation list of SI grade 2 published on 14/10/15 and the supplementary gradation list dated 30/12/15 as annexure A/25. It submitted that he also wants to challenge the review DPC dated as 26/6/15 so far it relates to respondent number 6 and the order dated 2/7/15 wherein the respondent number 6 has been given promotion. It submitted that those documents were not in his knowledge of the applicant when he filed OA or rejoinder and the amendment is formal in nature and would change the nature and character of the case. Hence, he prayed for allowing the amendment. And counsel for the respondent submitted that readings in this case were completed 2019. Therefore, amending the OA at this stage would change the nature and character of the case. It is seen from record that OA was filed in the year 2016 and counter was filed in the same year. The applicant filed the rejoinder in the year 2019. The documents the applicant wants to challenge belongs to the year 2015, that is well before the OA was filed. The plea of the applicant that he was not aware of those documents after lapse of 10 years of filing OA is not enough. The pleadings are complete in this case and is slated for final hearing. The amendments are to be made would require further counter from the respondent. Therefore, we are not inclined to allow the MA.
What happened on 1st September 2025 when it was fixed for hearing?
That could not be reached on that day.
Now it is still pending?
It is still pending.
Pending. So let us see your MA. This miscellaneous application 103.
Yes. That is at next year. Plus annexure 6 started from annexure 6 of the present petition started from page 31. The applicant in the above way has asked for quashing of annexure A/5.
No, we just want to see that particular averment which you have mentioning that it was not within your knowledge. That is why while filing the way in 2016 or even in the rejoinder you could not incorporate, but after
Miller, paragraph 3 and 4 I am reading out that in subsequent period final gradation list of SI grade 2 has been published by respondent number 2 by the order dated 14/10/15 and a supplementary list of above final gradation list has been published by the above authority
by the order dated 30/12/15, wherein the respondent number 6 has been placed against serial number 669A, and the applicant, despite his seniority, has been placed against the serial number 389 below him. That publication of final seniority list of SI grade 2 was not within the knowledge of the applicant, for which he had challenged the provisional seniority list dated 7/7/15 on annexure A by 5 of the OA. During the pendency of the case, the applicant having come to know about the final selection list of SI grade 2 dated 14/10/15 and is a supplementary gradation list dated 13/12/15, seeks to bring the same on record and challenge the same, praying for their quashing the extent necessary, for the reason that his challenge to the provisional select list of SI grade 2 under annexure A by 5 without putting up any challenge to the final seniority list of SI grade 2 shall not be helpful to him for the redressal of his grievance. The applicant seeks to include the final select list of SI grade 2 dated 14/10/15 and the supplementary gradation list 13/12/15 with OA as annexure A by 25 in continuous with the annexures made in the OA and the regard affidavit 3/11/9/19 is such OA.
The provisional gradation list was challenged. The grounds are not changed.
Yes, sir.
The only you came to know about the final gradation list and supplementary gradation list. You want to incorporate that. What is wrong in it? What is the question of delay?
But 2005, the gradation list was made final, and it came to his knowledge.
Thereafter, he is not changing the grounds. Provisional gradation list as it is was challenged.
Yes.
2015 to 2019,
right. Delay is
he
there.
was in deep slumber.
Delay is there, but what is
Well, I don't have
substantive
anything, but
change?
there is a private party, opposite party number 6, his interest is going to be affected.
Private
Opposite party number 6, because his seniority is likely to be disturbed.
You are appealing for
Union of Courts.
except this 1, 2, 5, and 6 is that man.
Yes,
the
sir.
notice has to be issued.
Yes, OP number 6 is not contesting the OA. OP number 6, private opposite party to whom I have pleaded, he is also not contesting the OA in spite of
Maybe,
service of
but
notice.
here you have made a
Yes,
party.
Yes, Miller, I have a party.
But one more thing, one more problem may come, because now the seniority issue will be there. You have to implead all of them.
Yes, exactly.
And that's the whole difficulty. Unless you implead them.
Miller,
you are
in the final list.
not only this man, but others who have placed above you.
Miller, particularly in this case, the response number 6 being 10 years junior to this person.
No, in the final senior list, wherever you are positioned, and the people those who are affected, you have to implead them. Once the amendment is allowed.
Miller, my limited
this man, but also so
the other people. We don't know.
Applicant and the respondents both have retired. Only the hard boarding is this applicant who is pretty senior to the respondent number 6 by 10 years, and that respondent number 6.
What benefit you will get?
Miller,
you have already retired.
Miller, some financial benefits will be allowed because he is claiming he was to be promoted to the post of SI grade 2 from the date, but he has not promoted. Whereas in subsequent period, the respondent number 6 was given retrospective promotion by virtue of one order of High Court after long 25 years. He was initially working on delegated basis, and
when you retired from sir?
Miller, this petitioner is retired in the year 2020, and he has retired from the year 2018. Only bone of contention he was allowed. He big 10 years junior. His service was not regular. He was appointed in the year 90, and this petition was appointed in the year 81. 10 years senior in the federal cadre, but by virtue of one order of regulation, and he was allowed retrospective promotion in the year 2025. 2000.
What is your prayer in the OA? Let us see. If you say that he is not going to be affected in any way, let us see the OA prayer.
Where is the OA?
Miller.
As per order number 1,
After
release of
After hearing the counsel for the parties, we further pleased to quash the input provisional seniority list under annexure A by 5 to the extent indicating the seniority of the applicant.
You see, on the basis of that seniority list, he has been placed as a SI and ultimately has got the reliefs.
Millard,
because the whatever payment he has been made, extra payment.
Milord,
So he has getting that because of that list, seniority list, and you want to quash that, and you say that
my grievance is that
whatever you are given is likely to be affected because of that seniority list. He is getting some more financial benefits than you, and you want to quash it. Will not include them.
Milord, my context, my submission to Lordship is that his placement above me in the provisional accreditation list is absolutely illegal.
He is not alone. Many other people.
No,
in the final.
This person, so far as this person,
No. What will happen is, see, try to appreciate. What will happen is, suppose you allow the petition, and many other similarly situated people will keep on filing OAs. Thereafter, there will be a floodgate, and he has got why not I? Then OAs will follow. Once your petition is allowed, even if they're retired, everybody will start asking notional promotion and financial benefit and those things. You are opening a floodgate.
What has happened?
And that litigation 2016 you filed, and today you reopen everything, then it may.
Ultimately, you will get the benefit. There is no question of this writ petition has been filed by the petitioner challenging the order dated 37/2025 passed by the Reliance Administrative Tribunal in MA number 103 of 2025. It's a further prayer to allow the prayer of the petitioner for amendment as sought for in the said MA, which arises out of way number 361 of 2016 for effective adjudication of the case on merit. Top. The petitioner filed OA number 361 of 2016 inter alia with a prayer to quash the provisional seniority list, which is annexed to the original application as annexure A by 5, to the extent indicating that the seniority of the petitioner vis-a-vis the opposite party number 6 and also the later dated 13/8/2015, which is annexed as annexure A by 1 to the original application with a direction to the opposite party to give promotion to the petitioner in the post of SI grade 3 bracketary grade 2 from the date his case was enlisted for consideration of DPC held on 23/4/2015 for the purpose of promotion to post of SI grade 3 with all consequential benefits by convening review DPC for that purpose with a further direction to place the petitioner above the opposite party number 6 in the seniority list of grade 2, and also to pass the order of rejection dated 28/2015 passed by the opposite party number 2 in annexure A by 11 to the OA. During the pendency of the original application, as it appears that counter affidavit was filed by the opposite party, and the petitioner also filed the rejoinder to the counter affidavit by 2019. And after the pleadings were completed, the case was placed for hearing. And at that stage, the present MA, that is MA number 103 of 2025, was filed with a prayer for certain amendment to the original application. The London Tribunal has been pleased to hold as follows. Quote, it is seen from the records, inverted comma, accordingly, MA is dismissed. The Land Council for the petitioner, though urged and also taken the ground that the publication of the order dated 14/10/2025 passed by the opposite party number 2 and a supplementary list of gradation list which was published by the said authority by the order dated 30/12/2015, wherein the opposite party number 6 was placed above the petitioner, was not within his knowledge, for which he intends to challenge, for which he has only challenged the provisional seniority list dated 7/7/2015 and not the final seniority list dated 14/10/2015. So also the supplementary gradation list dated 30/12/2015. But the London Tribunal was of the view that after a lapse of 10 years of the filing of OA, the amendment is would require for the counter from the opposite party, and we are also of the view that there are likely to be many issues if such amendment is allowed, and we should not only necessitate the addition of parties, not only the opposite party number 6, but also other persons who have been promoted above the petitioner in the meantime and might have retired also as submitted by the Land Council for the petitioner. Therefore, we find no illegality or perversity in the informed order. Accordingly, the writ petition stands dismissed since the original application is of the year 2016. The London Tribunal shall do well, and the pleadings are complete. The London Tribunal shall do well to expedite the hearing of the original application. Accordingly, so answer is next.
Item 7.
They may be reflected.
Below. I'm for the petitioner, the petitioner is neither a borrower nor guarantor and as well as the mortgager also. But the fact remains, beloved, petitioner's father was expired on 8th June 2016.
Who is appearing for the other side?
I'm appearing for the bank.
Bank. What is the position now?
The 13-4 has already been done in the year 2021. 13-4 has already been done in 2021. And Section 14 application is pending. But the actual facts is that she is the one of the legal heir of the father, who was the owner. There's a partition suit they have filed later on in the year, I think 23 or 24. So 21. Now she is coming, what she is saying that I am neither the borrower or she cannot do because she has not borrowed. Property was her father, and there are 5 to 6 legal heirs. So she is one of the legal heirs. If she is affected, Miller definitely can approach DRT. And the possession 13-4 is already in 2021.
So not only the parties, but whosoever is agreed.
Whosoever is agreed, any person who agreed.
My lord, my representation annexure
one is pending before the bank authority.
If you would have been in this side, what would you have?
You would have strongly objected.
You have been doing it.
My
No, when you are appearing for
my
bank.
representation to be disposed of, and not here, then I approach.
Whenever you will appear for bank, then we'll allow like this.
ବେଳେବେଳେ ପରେ ତାଙ୍କେ mortgage ଟା ପରେ ନେଇଛନ୍ତି without our consent.
For considering the
I am the one of the
representation for one-time settlement dated 24/10/2025 and for a direction to the bank not to take any coercive action against the civil property till the disposal of the OTS. Mr. Sahoo, the land counsel for the petitioner, submitted before us that the petitioner was neither a borrower nor guarantor in respect of the loan amount which was held by the borrower, namely Devraj Behera, and who
in the year
had,
2000,
after taking the financial facilities from the bank, couldn't clear the loan amount, and but for which some proceedings have been initiated in the meantime. The land council submits that the petitioner has submitted the OTS proposal and by annexure 1, which is dated 24/10/2025, and though it has reached to the bank.
No, that was rejected.
Acha,
Because
we had mentioned it.
My lord.
Though it had reached to the bank, but no communication has been received, and therefore direction may be issued in that respect. The land counsel for the bank, what is your वकालतनामा करिए ना
We are filing during course of the day.
So আমি দেখি দেবো filing file the वकालतनामा which is taken on record and submitted that the representation of the petitioner under annexure 1 has already been considered by the bank authorities and has been rejected, and it has been communicated to the petitioner also. Moreover, the file submits that the 13/4 notice has been issued in the year
28th October 2021.
28 August.
October 2021.
And 28/10/2021. And the proceeding under section 14
is
of
pending.
the Satisai Act
Pending.
is also pending. Before whom?
Before the Chief Judicial Magistrate.
Chief Judicial Magistrate
Bhubaneswar.
Bhubaneswar. It stops. In view of such submission made by the land counsel for the bank, since alternative efficacious remote so and so is available in view of the decision so and so, it is open to the petitioner to seek for appropriate remedy according to the
within 7 days I will approve, because they have taken.
I mean, the time limit is
You do it. Why 7 days? 2 days. Do it.
You do it.
My lord, the reason being, I am one of the co-sharer.
Will not pass any interim order, so it is open to you.
Milord,
and you may face also a that limitation issue, and you take appropriate remedy.
Milord, because there is no scope for getting the notice, because my father was expired in the year 2016.
That you convince the other
As
side.
per my reliable sources, bank has taken mortgage 2018.
He is your father. He has taken a loan. If you say nothing is available,
father, brother, milord, sorry, brother. Father is not a loan. I succeeded the property as a co-sharer, milord.
Okay. All right. Next.
Is a co-sharer, but milord, dispose of within, because in accordance with the law, they will.
In accordance with law,
limitation, many issues are there.
Milord, because I have comment regarding rejection, I have not obtained.
Yes.
One letter. A communication may kindly.
I'll give it again. Within
the
2 days.
land counsel for the counsel for the petitioner submitted that though
pending and status quo,
bank is stated to have issued the rejection order to the petitioner, but he has obtained the instruction that the petitioner has not been served with such a rejection order. The London Council for the bank has supplied the rejection order to the London Council for the petitioner in court today. Yes, next. Yes, next.
Try to try to draw limitation from place.
Yeah.
May I please, Your Honor? My lord, the petitioner is a loan. He has held a loan of 3 lakhs in 2009, and he already paid 14 lakhs 43,620. However, they have issued a 13-2 notice by an expert for my lord. And
No,
he
13-2 notice is 13/11/2013.
20,
Right. So they are, if you come to the relevant paragraphs, then you will find that you have been given opportunity that you have to file your response in view of 13(3)(a). So that you are not doing. That is very clearly mentioned here. When the non-performing performing asset was made, and then how it led to issuance of so and so, what is the amount also.
That
It
is
is
4 lakh.
mentioned in paragraph number 5 that since the borrower has committed default in repayment, so and so is liable to pay amount of this plus interest and other charges, so and so together with interest, so and so, and we give you notice, paragraph
ma'am.
number 6,
Yes, my lord, they
that
have given notice.
failing payment of the above amount with the interest and charges till the date of payment, we shall be exercising all or any vested rights vested on us under 13(4). So 13(4) they have not yet
Issued,
in-
my lord.
right.
Yes.
So have you submitted the representation?
Yes, my lord, I have a
So
representation.
what are the
Yes,
response you have got?
already I have deposited. Now outstanding amount is 1,51,000.
ଆପଣ 13(3) ରେ ଆପଣଙ୍କର ରେସ୍ପନ୍ସ ଦେଲା ପରେ annexure 4 ଆସିଲା, କଣ ଆସିଲା? The loan amount
Annexure 4
on the
Annexure 3 for OTS, my lord. I have a recommendation given the OTS for OTS.
you from our so the total dues of this also is your request for OTS decline is
Decline. They have declined, my 1,41,000. Remaining amount is 1,41,000 is the outstanding amount as per 4/11/2025.
So
I am ready.
This letter is dated 6/11/2025.
Yes, ma'am.
So the pattern post stage is in.
Are you ready to deposit?
Ready to deposit, ma'am.
How much?
My lord,
The outstanding dues is
1,41,000.
1,41,000. It can be deposited. What is there?
You deposit here, we will issue notice.
My
Finish
lord,
it up.
my lord, I pay for OTS, my lord.
1 lakh OTS.
What for OTS, my lord? If they allowed, I will deposit, my lord.
That is the whole difficulty. You invite problem. You deposit it, we will finish it up.
Sir, if some percentage will be deposited, I will deposit.
You better claim that by you regarding the first is wrong. And for this reason, due to the amount yet to be paid in the loan account, as on date only 1 lakh funds. So
Deposit
the amount
and we will finish it up. Otherwise, they'll drag you, and this 1 lakh will be 10 lakh.
And then the
Within 2 months, you just see.
Already I have paid 14 lakhs.
Bank does like that.
Already paid 14 lakhs, 3 lakhs loan amount. And outstanding is 1,41,000. I pray for
Someday, if you don't pay within 1 month or 2 months, it will be 10 lakh.
Sir, some percentage will be
This kind of
20%
calculation.
or 30% will be
they
deposited.
will issue 13(4), then you have to go there. So now that stage has not come. That is, you are asking that you deposit us, let us issue notice and see that what can be done, and if some amount is, you can get back that amount from the registry.
Yes, madam. 20% direct deposit.
And it will be deposited in a that
interest bearing. We are not going to disburse if deposit.
So some percentage, my lord, kindly please. 1,41,000, 20%.
50%.
50%.
50% you deposit by day after.
30%, my.
That is the reason the bank is rejected. You converted us as a bank.
Sir, ठीक है.
You are going to bank.
नहीं.
Going to pay the bank, not to us.
ठीक है.
Pay it.
हाँ,
50%. Why negotiation?
ठीक.
This petition has been filed by the petitioner Sanjay Kumar Nando with a prayer to pass the letter dated 6/11/2025 issued by the opposite party number
2, my lord.
2 in rejecting the OTS application of the petitioner and asking him to repay the entire loan dues at an earliest. The Land Council for the petitioner submits that when the petitioner received a demand notice dated 15/11/2023 under Annexure 2, he submitted a representation under Annexure 3, wherein he has stated that he has deposited a sum of rupees 14,43,670 and 78 paisa against the loan till 23/9/2025, and the balance amount is shown to be rupees 1,41,483.78 paisa, and he has requested the bank to settle the matter under OTS scheme, waiving the total interest accrued for settling the loan account. However, under Annexure 4, which is dated 6/11/2025, and imbued in this petition, the bank has not considered his OTS proposal and declined the same. Stop. The Land Council for the petitioner submits that he is ready to deposit a part of the amount which is stated to be outstanding against the petitioner before this court, and notice be issued to the opposite party banks so that matter can be settled, and if the petitioner is found to be if it is found that the petitioner is to give any amount to deposit any amount, the same shall be done. Stop. In view of such submission made by the petitioner, since the 13(4), the proceeding, the notice under section 13(4) of the Surface Act has not been issued in this case, and taking into account that the amount involved is rupees 1,42,576, and the petitioner is ready and willing to deposit a part of it, we direct the petitioner to deposit 50% of the aforesaid amount before the registrar judicial within 2 days, and in case such amount is deposited and requisites are filed for issuance of notice to the opposite party bank, by speed post with book delivery, the registry shall proceed to issue notice that the opposite parties fixing a returnable date. Matter will be listed on 22nd of December 2025. Till if it is made clear that if IL number like the in view of the submission made by the Land Counsel for the petitioner, it is directed that the opposite party number 2 shall not take any coercive action till the next date, subject to deposit of the aforesaid amount as directed above. And it is made clear that if the amount is not deposited as directed, it is open to the bank to proceed in accordance with law.
Sir, sir, within 7 days, 2 days.
କରିଦେବେ ଯେତେବେଳେ ନୋଟିସଟା ତାପରେ ସେଠୁ ଯାଉଥିବେ ଏଠି ପୁରା ଏଠି ହେଇଯିବ ନଟ୍ ମେଣ୍ଟେନେବୁଲ ତାପରେ ସେଠିକି ଯାଉଥିବେ ତାପରେ ସେ ବଢେଇ ଦେଇକିନି ତା ଦେହରେ ଚକ୍ର ବୁଦ୍ଧି ସୁଧ ଅମକ ସମକ କରିକିନି 14-15 ଲକ୍ଷ ଟଙ୍କା ଦେଖେଇବେ ତାପରେ ଆପଣ ବୁଝୁଥିବେ ୟେସ୍ ନେକ୍ସଟ
Sir, ticket time तो
next
Item 10.
Your Lordship, in item 10, I am there virtually, Your Lordship.
Yeah.
Your Lordship, in item 10, the petitioners are borrower and guarantors, Your Lordship. Your Lordship, may I draw your kind attention to the list of dates and events, Your Lordship?
Because you are challenging the sale notice, you have the alternative remedy, go and approach there.
Your Lordship, I have not received 13-4 notice, Your Lordship.
And
They have
sold even. And it is stated that that has been already sold. Yes. So the remedy is open to you. Go and approach. Yes. Alternative remedy DRT is there.
Your Lordship, I have filed before the DRT as well. Diary number has come.
Okay. So already filed. Then already filed. Why have you come here? Yes.
Your Lordship, because it is taking time and the date was on 28/11, Your Lordship.
Here we have to monitor the thousands of cases which are pending and old cases are pending, and we will monitor here that which matter is to be given preference, which matter is not to be.
Your Lordship, my limited prayer is that the bank.
Where you mentioned the OA number?
The diary number means 1079 of 25 minutes.
Where is that?
There, I don't know this.
Achha.
Your Lordship, I have
got that.
Yes, I have got that.
Diary number
1079 of 25.
1079
of 25 minutes.
Of 2020. Look, the writ petition has been filed by the petitioners with a to quash the e-auction sale notice dated 8/11/2025 under Annexure 1 and with a further prayer to declare the demand of rupees 1,16,703 towards the term loan as per the notice under 13(2) dated 33/2007 as illegal and further prayer to restrain the opposite party bank to proceed with the auction sale and disturbing the petitioner's peaceful possession over such property until the matter is decided by the DRT cutter stop. This is brought to the notice of the this court that petitioners have already approached the DRT cutter in
Essay under diary number. Essay under diary number.
And by filing an essay and the diary number 1079/2025 has been registered and the property in question has already been sold.
Yes.
The reference
and 25 minutes. 25% also deposited.
Property has been sold in favor of one. Kiye the Nadagam? Basudev Prushti.
Again.
Basudev Prushti, who has already deposited 25%
20,
of the bid amount. The relevant document, sale intimation letter dated 28/11/2025 is filed, which is taken on record. In view of so and so decision, since alternative remedy is available and the petitioners have approached the DRT, we are not inclined to entertain the petition. Accordingly, the petition is disposed of. Though a submission was made before us by the Land Council for the petitioner that DRT be directed to expedite the hearing of the matter, but since the petitioner, there is some defects perhaps.
Yes, sir.
Since the petitioners have not removed the defects for which the case essay has not been registered, it is open to them to remove the defects and place the matter with the DRT for the expeditious disposal. Yes, next.
Presence maybe.
Once he is present, आपको file को देंगे.
Because in course with
पर नोटा file करिए should be there. है
Okay.
Now is taken on record for the name plate. Yes, next.
Item 11.
Item 11, Your Lordship, as per the last order, Your Lordship, I have amended the cost citus, including Bank of Baroda as a party, as Vijay Bank opposite party number 3 and 4, Your Lordship, has merged with Bank of Baroda. I filed an IA for amendment.
Appearing for so and so. In the meantime, Vijay Bank has merged with the Bank of Shell. So appearing for the period 6 times to amend the cost title, including Bank of Baroda as a party, so that notice can be issued.
And appearing to opposite parties 1 and 2.
If an interim application is in filed, the same shall be placed on. So you have filed the interim application, IN number so and so. You have received the copy.
I will.
Yes. Look on the IN number 14809/2025. There's an application filed by the petitioner for amending the writ petition and to allow the schedule to form a part of the writ petition. The Land Council for the you are appearing for whom?
State Bank of India.
Land Council appearing for the opposite party number 1 and 2. I have no objection to the such amendment. Accordingly, the prayer made is allowed. The Land Council for the petitioner shall file consolidated.
You have filed, Your Lordship.
You have already filed?
Yes, sir.
Fine, sir.
Consolidated cost item.
Fine, sir. Consolidated cost title from file करके देखिए. You annexed it to the IA.
Yes, Your Lordship.
You file कर ले. IA the kind of
2025, Your Lordship. I have filed, Your Lordship. I saw the hard copy, Your Lordship, right now.
So you should have annexed it with that IA. देखिए कौन पे file करेंगे. इधर तो कहीं नहीं consolidated अच्छी है देखिए ना. Consolidated cost title ଗୋଟେ file कर देंगे. आपने copy दीजिए. All right. When you file this consolidated cost title,
1/9/2025.
they stated that the consolidated cost title has already been filed. Let the same be placed on record on 1/9/25.
Yes, Your Lordship.
On 1/9/2025, the same be placed on record. Copy of the same has already been served on the Land Council for the opposite parties number 1 and 2. Now the notice has to go to those
Yes, Your
opposite.
Lordship, to Bank of Baroda.
The issue notice to the opposite parties number के कहाँ पर notice?
4, Your Lordship.
3 and 4. 3 and 4. Requisites for issuance of notice, like speed posted, proof of delivery shall be filed. You file the requisites during course of this week. Okay. During course of this week, matter be listed on such and such date. Yes, next.
Item 12.
It's going on now. Some of the facts were omitted. That's why I'm filing the amendment.
You have given a copy to Mr.
Yes, my lord.
Yes,
I have already.
Any objection?
No objection, your lordship may
Alright.
not record my concession.
IA number so and so is an application for amendment. The copy of the interim application has been served on the Land Council for the Union of India. And Mr. Mishra, Land Senior Panel Counsel is present. And after hearing the Land Council for both the parties and going to the amendments taken in the interim application, the prayer made in the interim application is allowed. And now the proposed amendments which form part of the writ petition. Have you filed?
They have already filed, ma'am.
Well filed.
What else, my lord?
Consolidated. There were data from
Friday 28th, my lord.
28.
They stated that the consolidated writ petition has already been filed. Friday mane amaro
28th, ma'am.
video 28.
Yes.
Acha, aschi. Okay. 28. The same has already it a stand in English. Huh? The same has not been attached to the file. Registry shall do the needful. So let it come and then we'll under the heading of it will come under the heading of phrase admission.
Yes.
Then okay. With this matter next week under the heading of phrase admission. Yes. We are just coming.
Item 13.
This case, my lord, I have filed an additional affidavit on 29/11/2020. It has not come perhaps because it is not in the list. Lordship may call it.
On that?
Item 13. I have filed an additional affidavit, my lord, on 29/11. Perhaps it has not come, my lord. 29/11. I have also served to copies to petitioner counsel on
What is
same
this
day.
case about?
This is, my lord, that attachment where your lordship has refused to interfere in the order of attachment passed by the confirmed by the adjudicating authority.
Our earlier order was there.
Yes, my lord. Then the petitioner challenged it before apex court.
Oh, that is passed in WPC number
23883.
Single judge has passed.
No, my lord. Single judge first passed, then your lordship has also passed 23883. Your lordship's order is on 23883 of 2025.
3883.
That is, my lord, in IA number annexure 1 at page 10.
Just a minute. IA
17647.
17647. 17647. 25. IA.
Yes, my lord.
Radhire, acha. Pass the order. Response for the petition challenging the eviction notice dated from petition. What we have heard there? Main citizen.
The Supreme Court has given you two options. Either you go to appellate tribunal, and in alternate you can move an application. Have you gone to appellate tribunal?
That. I will explain. Your lordship posed that question on the very day. I will explain that.
You should go there, appellate tribunal.
No, so far the appeal is concerned, what is the problem? It was not filed within time. After the order passed by the Honorable Court in the rate application, the liberty was given to approach and file appeal. Appeal was filed. Thereafter, in the main period, they took over the possession. So, in two issues, the petitioner went to the apex court for which the order was passed. Choice was given twofold. Either one is to opt. So far the first part is concerned, the appeal has not yet been admitted because it has shown some defects, some documents were not filed. So no ancillary relief can be granted unless until the appeal is accepted or admitted. That is the crux for which the petition.
That fault lies with you. If you do not remove the defect, then how the appellate authority can be blamed?
No, problem, my lord, just I am explaining. It is instruction. The documents which required to be filed along with the appeal memo, that was kept in the house which possession was taken over in absence of the petitioner. She could not collect the documents that would for which the defect.
What defect has been shown by the appellate authority? That we want to know. Let us know that.
On defect
because this application is an alternate remedy.
It's not.
Substantive remedy is the appeal.
Yes. Once you have approached the appellate authority, if there is some defect, and you have to remove those defects.
That was posted to 412, my lord, for removal of the defect. But I do not know exactly what are the defects.
Yes, can you also, we want to know that why have you not, and we will give that why if defects have not been removed, and you are once you say that suppose in the meantime defects will be removed, then you will get both the forum to adjudicate. That is not the purport of the order of the Honorable Supreme Court.
If you in the appeal, if you move application, if you get an adverse order, you have another option to come.
Crux of the matter because the appeal was not admitted. And it was shown some defects.
Because of these defects, Mr. Mahapatra, because as you rightly said, that because of the defects pointed out, since it has not been yet removed, therefore it could not have been taken for admission. Right? We want to know that it is up to you. It is the responsibility of the appellant of that appeal to remove the defects. So, why the defects cannot be removed and why you are insisting us to take up this?
Yes, my lord. The reason I have received that some documents are to be filed along with the appeal memo. The documents were kept in the house whose possession was taken by the ED. So he could not procure those documents.
That you can file an interim application. Look, sir, you have shown these defects, but I cannot file these documents because it is already in possession of the other side. They may ask, the appellate authority can ask that whether it is correct or not. Then that can be ignored, and the appeal
my lord, proposition is correct. Since it was posted to 412, I have no instruction what sort of steps were taken.
We list it after. We list the matter after.
Take down the learned counsel for the Mr. Gopal Agrawal, learned senior advocate appearing for the Enforcement Directorate, submits that on 29/11/2025 he has filed what is it?
Additional affidavit.
Additional affidavit, which is has not taken on record. The
copy has been
he further submits that copy of the such additional affidavit has been served on the learned counsel for the petitioner, which is not disputed by Mr. Mahapatra and senior advocate appearing for the petitioner. After perusing the order passed by the Honorable Supreme Court in so and so, we find that the Honorable Supreme Court has given option to the petitioner either to file the appeal before the appellate authority.
Application is to
Application
file. Appeal was already filed.
Application has to be made before the appellate authority, and in the alternative, he is also at liberty to file an application before this court for to seek restitution of possession having regard to the result of the appeal. It is brought to our notice by Mr. Mahapatra that senior advocate that the petitioner has approached the appellate authority, and since some defects have been pointed out, the appeal could not be taken up for admission. Stop. It is further stated that the date is fixed before the appellate authority on 4/12/2025 for removal of the defect. In view of such submission made by the land counsel for the petitioner, and we list this matter on, we are fixing it on 10th December 2025. The land counsel for the petitioner shall apprise us about the status of the appeal, which is sub judice before the appellate authority here. And the registry shall place the additional affidavit on the following meantime. Yeah.
Item 14.
May I please, the Lords? Lords, may I kindly see the last two orders, order dated 10/9/2025 and order dated 14/11/2025.
Okay, the first order that is 10/9/2025, we asked the London Council for the state to obtain instruction regarding the position of the rule that if an incumbent completed the basic course of training and also the probation period successfully. But on the ground of his medical unfitness, he could not complete 80 course of training, whether he would be removed from the service.
Yes.
And in the next order, that is on 14/11, 2025, as it appears, Mr. Nayak made a submission with us that such an incumbent who could not complete the AET course, that is anti-extremist training course, even if he has completed the basic course of training and probation period successfully, he can be removed. And he has relied on the Order 14 of the Indian Reserve Battalion Service method of recruitment and condition of service of Constable Order 2006. And we made a submission that every constable, like the petitioner, has to undergo not only the basic training but also the specialized training required for this job, to be decided by the DG and IG of police. So basic training you have completed, you could not complete the specialized training as contemplated under Order 14 due to your physical unfitness, and therefore you have been discharged, and according to the State Council, it has been done rightly.
My lord. Purpose to order dated.
It appears that said order not only covers the training of 9 months duration at the designated police training institutions which the petitioner has completed. However, where the specialized training required for the job is concerned, there is no such specific mention in the aforesaid order. Let an affidavit be filed clarifying this issue, which was mentioned in the order dated by a responsible officer of the state. Where is that affidavit?
Now the affidavit has been filed. Would you like to file response to this? You filed response because they have taken many grounds now.
That additional affidavit?
Yes.
Have you received a copy?
Today I have submitted.
You must file response.
It's a detailed affidavit has been filed. So it is all the things are against you as it appears. So if you want to bring something on record by way of a counter affidavit or reply to that additional affidavit, you can do it.
Reply I will file.
So many facts have come. You have to
in persons of the order dated 14/11/2025, the London Council for the state has filed an additional affidavit by the opposite party number 3, which is on record. A copy of such additional affidavit has been served on the London Council for the petitioner. Mr. Nanda, London Council for the petitioner, submits that since he has received the copy of the additional affidavit in court today, he wants to go through the same and file his response, and the matter may be taken off 2 weeks after. Lays this matter in the week commencing from such answer, January maybe. Yes, next.
13.
Time is short, so we cannot take it before this winter vacation. So let it go to January, second week of the month. Yes, next.
Item 15.
50 pass over. 15 minutes gas में से pass over.
Item 17.
Mental already pass over.
70.
70. Then you also keep it to some other thing because
You are for
I am the opposite party. Opposite party 5 to 10 in every two.
I am
which for the petitioner?
I am for the petition of the
We are
second
for the
case.
petition.
All are challenging the judgment of the
in some cases, Mr. Rautrai, you are also
petition.
For the appellate.
In the first case, I am for the appellate.
Oh, no, it's all right. But why you want time? Date fixed for final this matter should be disposed of. You will argue the matter or somebody else will.
Samir from
Samir
Das.
is not available today.
ଆପଣ ମାନେ
ଡେଟ୍ ଗୋଟେ ଦିଅନ୍ତୁ ଆପଣ ମାନେ କନସେନସସ୍ ନେଇକିନି ଡେଟ୍ ଟା ଫିକ୍ସ ଅପ୍ ହେଇଥିଲା ଡେଟ୍ ଟେକ୍ ଅଫ୍ ହେଲା ବେଳକୁ ଆପଣ କହିବେ ନାହାନ୍ତି ଆଜି ତ ଦିଅନ୍ତୁ ଡେଟ୍ ଆମକୁ give any date
any date in the month of January but no
January 10th.
No, December.
No, subject to availability of the land senior advocate. You are appearing for one senior advocate, Mr. Senior Advocate is also here. Convenience.
immediately after vacation.
Give the calendar of January 26 to the land council. Yeah, it 26 the calendar that you देखी दियो तो अपन जो date को तो fix up कर लो. But it will be on Monday, then Wednesday and Friday.
5th you also keep it fixed 5th.
Fifth is a Monday.
Monday.
Since the Mr. Samir Kumar Mishra, Samir Kumar Das, Land Council is supposed to argue the matter for the opposite parties number 5, 6 and 7. कहाँ पे appear court के
5 to 10.
5 to 10. 5 to 10. 5 to 10 in the first writ appeal. Writ appeal number 72 of 2020.
Yes, ma'am. 5 to 10, 72 by 20.
Just a minute.
5 to 10.
5 to 10. In the first writ appeal number 72 of 2020.
152 by 21.
Same opposite party.
Same.
And also in WA number 152 of 2021.
And 156 by 21.
And 156 of 2021.
And 160.
And 160 of 2021 is having some personal difficulty or what do we say? Is having some difficulty as personal difficulty. A request is made to take up the matter in some other day. The Land Council for the petitioners are present in the aforesaid Land Council for the appellant in the aforesaid writ appeals, and they have no serious objection to the prayer for adjournment. Accordingly, on consensus of all these parties, this matter on 5th January 2026. Yes, next.
Interim order to
interim order.
Minor,
all the writ appeals interim order.
Minor, regarding the interim order, I have objection. Interim order was continued till
that objection kari. 5th of January 2026. Sabu writ appeal achi to. Next. We taking as well. Yes, ma'am.
Item 18.
May I please, Your Lordship? Your Lordship, just have a glance to
Wait.
order
Item number
18, Your Lordship.
18.
Your Lordship, just have a glance to order dated 18/8/2025. Order number 16.
Eighteen 8/25.
Author as a person.
Counter affidavit has already been filed.
Minor.
On that day, we madam says that that is not available. Now it is available with you. It is available. Okay. So you have not filed any rejoinder.
My lord, I have not filed.
Okay. Now, what is your prayer? You come to that order. We have mentioned something in that.
My lord.
18/8/25.
My lord.
Order achi to copy.
My lord.
Yes.
This matter. The writ appeal has been filed by the appellant Muhammad Rizwan, challenging the order dated 14/1/2020 passed by the learned single judge of this court in WPC number 3, wherein the prayer made by the appellant for appointments under rehabilitation scheme was not entertained. In the writ appeal ground number J, it is stated that J. For that, it is a clear case of discrimination where documents clearly said that the application of two candidates was rejected. One is Mohammad Shakil, another is Abhay Naik. The said Abhay Naik and MD Shakil approached this honorable court challenging the said order where his name find place in the annexure 12 of the writ petition. This honorable court reminded it to the government, and accordingly government has given appointment to Abhay Naik and MD Shakil. But in case of the petitioner, the learned single judge has rejected the claim. When the retirement is given to the employee on invalidation ground with the same term and condition, the appellant cannot be singled out from others. Hence, this is a clear case of discrimination. No document in support of the averments in the ground has been annexed into the writ appeal. Counter affidavit has already been filed by the respondent number 1, and in para 4 of this aspect has been dealt with. However, the learned counsel for the state submits that counter affidavit is not available in the file, and he may be permitted to take counter affidavit in his pen drive. Learned counsel
So come to that relevant paragraph, madam, where you have dealt all this to. ଦି ଜଣଙ୍କର କେସ୍ ଆଉ ୟା ଭିତରେ ଆପଣ how you have
Yes, before advertisement, so there is no document has been filed by the appellant to this regard.
are you,
No,
are you disputing it? Are you disputing it that
Yes, no.
what perhaps it is his case that he, Abhay Naik, Mohammad Shakil, they all stand on the similar footing.
Yes.
And two cases have already been considered by the government and relief has been granted to them. So far as the petitioner is concerned, he has been discriminated. That is his case.
Yes.
So how do you say that the case of the petitioner is distinguishable from the other two, Abhay Naik and Mohammad Shakil?
Paragraph 4 of my counter.
These are all the cases of rehabilitation assistance.
My lord.
Yeah. Paragraph number 4 of your counter affidavit.
Yes.
Yes.
Can I seek a passover in this matter?
Oh, yes.
I'm not finding my hand notice.
So you do one thing, we'll take up this matter day after two.
My lord.
Okay. As free for this matter on 3rd of December 2025. Yes. Achha. Mr. Sushant Kumar Baral, Land Counsel for the opposite party number 225 is present. 3/12/2025. Yes, next.
Item 19.
Yes, Mr. Das.
May I please, Your Worship? Let state file this appeal by lot. Impugned order is at annexure.
ତାଙ୍କ ପାଇଁ କି appear କଲେନି ଏ ଯୋଉ ଭଦ୍ରକ women's college ପାଇଁ governing body or respondent number 2 ପାଇଁ notice sufficient ହେଇଛି କି appear କଲେ ତ ଠିକ ଅଛି ଆପଣ single judge କୁ order କୁ ଆସନ୍ତୁ.
Annexure 3, starting with running page 56, the relevant page is 58. 58. Order dated 23/12/19. Third, Mr. S.K. Das, learned counsel for the petitioner, and Mr. Babu, learned additional government advocate for the state. In the companion writ petition, the petitioner has inter alia prayed for direction to the opposite party number 1 and 2 to modify the approval order of the petitioner under annexure 4 and 5, and further direction to the opposite party number 1 and 2 to approve the appointment of the petitioner and release granting aid from 17/10/1998 under the provision of the granting order 1994, as has been extended to the similarly situated person throughout the state More so, the demonstrator of the petitioner institution under Annexure 6. The undisputed fact as revealed from the writ petition is that the petitioner being aggrieved by the judgment dated 17/3/2012 in the GIA case number 354 of 2012, the petitioner approached this honorable court in FAO number 179 of 2012. This court by order dated 26/9/2012 passed the following order. Therefore, the finding arrived by the tribunal holding respondent number 4 senior to the applicant for service having been rightly approved and she was entitled to block grant was completely erroneous. The tribunal having committed gross error apparent on the face of the record, the same cannot be sustained. On conjoint reading of the above mentioned provision of law, read with the material available on record, this court come to the equivocal conclusion that the learned tribunal did commit gross error apparent on the face of records, finding the respondent number 4 senior to the applicant for service having been rightly approved and it being entitled to block grant. Since such findings have been arrived at on the basis of the fraudulent document or no document, this court has also no hesitation to pass the impugned order dated 17/3/2012 Annexure 17 passed by the educational tribunal. In view of the above, since the impugned order of the learned tribunal has been quashed, the benefits are due and admissible to the applicant since her appointment as demonstrator in the psychology in Bhadrak Women's College be granted to her within 3 months hence. With the above observation and direction, the appeal is allowed. The judgment has been confirmed by SLP number so and so by order dated 18/3/2016. Learned counsel for the petitioner submit that one Suchitra Panigrahi, lecturer of psychology of the same institution, has been receiving granting aid from 17/10/98 as evident from Annexure 3 and the benefit has been extended to her as per Annexure 3. Learned counsel for the petitioner further submits that the petitioner being demonstrator is entitled to granting aid from the said date. Being aggrieved by the order under Annexure 4 and 5, the petitioner has been deprived to differential granting aid which she is entitled to. Therefore, the learned counsel for the petitioner submits if a direction would be issued to the opposite party number 1 and 2 for disbursement of the differential granting aid from 17/1/98, then the grievance of the petitioner shall be redressed. Mr. Babu, an additional government advocate, however, does not have serious objection to the course of the action. Since the dispute lies in very narrow compass due to uncontroverted factual and legal position, the writ petition is disposed of with a direction to the opposite party number 1 and 2 who approve the appointment of the petitioner and release the differential area, treating her entitled to GIA from 17/10/98 under the provision of GIA Order 1994. Accordingly, necessary modifications order be passed within a period of 4 weeks and admissible area be paid to her within a period of 8 weeks thereafter. The petitioner state now challenging this order because Honorable Apex Court, the similar question was before Honorable Apex Court. Honorable Senapati.
That case has no application so far this present litigation is concerned. This is listed in.
Where is the order dated 18/3/2016 and SLP 8129? Do you have that?
I have all the copies. It is right from the tribunal. To
I can't hear it. I was repeating. I was repeating.
No, it was Ashok Panigrahi.
No, I was repeating.
Again?
In this matter, I was repeating. I was repeating.
The cook is. Anup Senapati has nothing to do. Amok case that is relying upon a judgment. Anup Senapati has nothing to do.
The question
is the original order. Upon jota ei case re jota SLP jaythila, Mr. Ashok Panigrahi was there, not my lord.
No.
Anup Senapati now he is relying on.
He is placing reliance on a judgment, and
I have taken a stand in
Place this matter before some other bench in which one of us, Justice S.S. Mishra, is not a party. Yes. No.
But that judgment settling the entire issue. Just check it.
That has nothing to do with this present case, sir. Because this is a lis pendency and decided much earlier to that judgment by the tribunal of even of the Supreme Court. This case was settled as.
Next.
That item 15, my lord, it was passed over.
Item?
15. No, 15 ta pass over. The judicial service. Employee member. My learned friend was to submit. I was in the hand of the.
No, ठीक है जी. 15 का ये document 15 ने.
Item 15.
When we see the last order, the referral issued to United State Council take instruction. 14,1125 order. I have already exhaustive order was passed on that date. And the issues I have raised.
You are appearing for the High Court.
Yes.
Even you know a panel is that.
Yes.
Oh, that copyist is not a cadre post.
Yes. Already that rule has been amended. That part of given. That is why Mr.
Yes, yes.
Sir,
Instruction on adopted last year on 24th November. The government has already communicated the registrar judicial to take effect and necessary action on this issue. The letter has communicated. I have served to my friend.
No. Last order to the but kindly see the 14,1125.
इंस्ट्रक्शन गवर्नमेंट का रेजिस्टर हो गई
एटा जी 24/11 तो एबे माने ओ ई
तापर आपन को ऑर्डर बेसिस
14,11 रे इंस्ट्रक्शन टा मगाइतला से
अच्छा इन इनवाइटिंग स्पॉन्सर along with a copy of the order
that we have said in the order also.
Kindly
देखनी है चल देखनी single protocol है ना पहले देखिए single protocol that single cadre.
Yes, that has been omitted.
We have taken note of.
And that the government has already preferred to take effective steps on that issue. The order of this annual report has influence that has been also taken note of by the government.
To request to take necessary action as deemed for may kindly be taken for filing instruction in the matter within the stipulated date.
After this order, this has been.
So what action has been taken?
On that point, my lord, I will take instruction. I have not communicated the said order.
जहाँ को आपण को डिसीजन नबा को हाबो गवर्नमेंट देइछन्दी ना तेणु आपण को मु जानि नि आ की जानिबो state government ro letter which is addressed to you mean to the Orissa High Court.
Yes.
Take a necessary action on such and such date. So you are supposed to apprise us whether any action has been taken or not. You copy.
Just now I have seen it from my lord and friend mine.
Now, have you got a copy?
Yes, the photocopy.
Please give a copy so that
I have given a photocopy.
We can take up this matter next week so that
yes.
If any.
Apart from that, if you lordship allow me, I want to submit this.
To action then
next week.
Suppose a decision might have been taken which may be favorable to him
yes,
also. So it would be unnecessary exercise of our time.
You said you used it in a single cadre.
Yes.
That has been deleted.
Now,
so therefore, pursuant to that amendment, this communication has been made to you. This we have reflected in our earlier order.
Yes.
Thereafter, this letter.
It seems that in pursuance of the order dated 14/11/2025 passed by this bench, the government has requested at later dated 24/11/2025 to the Registered Judicial Orissa High Court to take necessary action as deemed fit. Stop. The Learning Council for the state has produced such letter before us, which is taken on record. When we made a query to Mr. Ramakrishna Bishoy,
Yes.
the Learning Council, who is appearing for opposite party number, as to whether any action has been taken by the opposite party number 2 on receipt of the communication made by the government as per the letter dated so and so 24th November 2025. He seeks for an adjournment till next week to obtain such instruction and apprise this court. Is this matter? Kebe rakhiyo apun rapun. On 8th of December 2025. It also stated that. Yes.
Item 20.
In item number 20, by August 4/8/2025, your lordship will direct if any possibility of amicable settlement or regulation can be done. It says negative.
Which order you are finding out?
4/8/25.
4/8/25. Mr. Rotho is there for respondent number 1 to 24.
Yes.
Mr. Purohit is there for 25 and 26. So it is also pointed out by Mr. Purohit and counsel for the university that repeated letters were being sent to the state government for the purpose of regularizing these candidates as against huge number of vacancies, but to no avail. At this juncture, so submits that she would seek instruction as to whether one-time policy decision for the purpose of regularizing these candidates would be worked out or not. Let the state council fix as the form.
Cancel 17/11/25.
Decision has been taken to appoint these candidates as executive assistant as against 23 numbers of vacancies of junior assistants in the review meeting held on so and so under the chairmanship of the chief secretary with the
Chief secretary was a signatory to the appointment. For that reason, and the request of amicable that been turned down by communication dated 22/9/2025. And the other was trying to persuade with the government. Can I take sick for 1 more week?
It has to be taken up at the highest level.
Yes, sir. Because the chief secretary himself was a signatory to the appointment letter. So letter by the rejection by the additional secretary doesn't seem right.
Chief secretary got a decision no change.
Yes. For that, can I sick for 4 weeks?
One time that will not be a precedent for others, but
yes,
so कितने वर्षों प्राय से मैंने आप ये कर लेना काम कर लेना 12
within 5 years they filed the writ application. During pendency of the litigation, they are continued. So within 5 years they came to the court.
All right, listen to Ms. Sugarakmi Devi, National Standing Council, seeks some more time to obtain instruction as per the order dated 17/11/2025.
There is no order in 17/11. It has to be 4/8. That's the continuation of
the order dated 4. No, we have also indicated on that 4/8/2025, and also they are on that one-time policy decision To regularize the said employees cannot be paid the Shahita Children cannot be. That's it according to 4/8/2025. Mr. Shishir Kumar Purohit, Land Council for the respondents number 25 and 26 is present. Anybody is present from on behalf of Mr. Swanto is present on behalf of the senior advocate Mr. Jayant Land Council for the respondents number 1 to 24. This matter January 2nd will be represented. Yes. But fix it on a Monday or Wednesday or Friday. Okay.
Item 21.
Yes. Samantha may not say paper day after tomorrow.
You are for the petitioner. Who is for the other side? Madam is there. Any objection day after tomorrow? Mr. Swansu appearing for Mr. Lalatendu Samantray, counsel for the petitioner. 6th on an adjournment day after tomorrow. Kulochana Patra and CGC.
CGC.
Has no objection. List this matter on 3rd December 2025. Yes.
Item 23.
Please,
Yes.
So here the petitioner prays for regulation of his service. My lord has already put in more than 29 years of service. Earlier the matter was forwarded to the mediation
Failed.
Yes, ma'am.
Unsuccessful. Okay. So now you have to argue the matter on merit.
Yes, ma'am.
And pleadings are complete.
Pleadings are complete, madam.
So where is your that date chart?
I have filed a date chart on 30/8/2023.
Sure. Date chart for what?
No, I'll file a fresh date chart, my lord. With
You want time to file this?
file a fresh date chart with it.
You are Mr. Swine.
Yes, ma'am.
Mr. Kunal Kumar Swine.
No, Kaushik Swine.
Kaushik Swine. The London Council submits that he intends to file a fresh date chart and some time may be granted for such purpose.
Next week, ma'am.
Ask Fred for this matter on 10th of December 2025. Copy of the date chart be filed in the meantime, and copy of the same be handed over to the London Council for the state. You file it in advance so that it can be digitalized.
Yes, ma'am.
Where you face problem.
Item 24.
Yes.
I am the opposite party number 1.
Yes, Mr. State Council. It is your case. Mr. Mahanti, item number 24. State is the petitioner. What is the prayer? Which order you are challenging here? I prayed for next year. The file is not there.
The opposite party has retired more than 20 years back. 22nd year.
He is the petitioner having no file. What can we say?
File you have missed or what?
I not. No, you can take it in the pen drive also. The entire thing is here. There is no problem. If you are not getting the file in your office,
take extra pen drive.
that will be better. So once you get it, go through it. We will take up next week. Land Council for the state. 6 for an adjournment till next week. On the ground of non-availability of the file. Mr. Saroj Kumar Das, Land Council for the rigid parties present.
No, I am for the opposite party number 1.
Ravi Naran Naik.
Yes.
Mr. Ravi Naran Naik, Land Council.
My lordship, item, I am from OP2, on behalf of Saroj Kawada.
Just a minute. On behalf of opposite party number 3 is present. So also the Land Council for the opposite party number 1. This matter on 10th of December 2025.
Item 25.
My pleasure, lordship. On behalf of Honorable Lekha, is another code. Pass over this item. I am appearing for 2 to 4. I need some more time to file to obtain instruction regarding this. Regarding taking into account the continuous service of the petitioners. Regarding regularization of the present petitioners.
Acha. You are appearing for whom?
2 to 4, my
My lord, I am appearing for OP number 1, my lord.
Land Council for the petitioner. Six for an adjournment. Land Council for the opposite party number 1. कहाँ ना लिखा वो बीके पारी तो
My lord, CK Monty, my lord, CGC, Central Government Council.
कहाँ ना तो
CK Monty, my lord, Chandan Kumar Monty.
So and so is present. Mr. What is your good name, man?
Abid Sahu. A Sahu.
Give it in writing. So and so appearing for opposite party number 2 to 6 for an adjournment to obtain instruction relating to the regularization of service of the petitioner. As prayed for this matter, Asudas in 10/12/2025.
Published, my lord.
Item 26.
Item 26 means I am for the opposition of 4, 5, and 6 millers. I think that it is not maintainable here because section 18 is there and the essay is pending for disposal millers. The virtue my lord, it has been stayed, further proceedings stayed. And when it is
the auction procedure,
yes,
he seeks for a direction for handing over the auction property. In the meanwhile, that and for the OP number 1 is the machinery to hand over the possession also. The meanwhile also that DRT has directed the bank not to proceed with property.
Yes, madam.
Your also on basis of that, we have filed this rate application challenging that order of DRT.
No, that order is to be challenged. What they are
Section 18
not in the section 18 before the appellate authority not here.
Yes.
There is an appeal lies against the order of the London DRT. So what they are objecting that you are to approach the appellate authority, not before this court. After the appellate authority disposed of the matter, you can challenge here. So that is their preliminary objection. What do you say?
In this regard, please grant me some time.
That is illegal.
Lordship, on this matter, my senior is appearing.
Okay, it's all right. Which specific order you are aggrieved?
Lordship,
What's the proceeding of 146? Essay
the
146.
proceeding will be what?
Proceeding can't be quashed like this. You say proceeding can.
In fact, I filed the IA. That IA has been taken up because I am the auction purchaser. So, Your Lordship, I am paying the monthly installments to the bank, and from the I have taken.
You see, one stay order has been passed for which you are agreed. So you are to file an application or challenge that order so that either two things, either the essays should be disposed of at an earliest. Number two, if you want to vary that stay order, then the remedy lies elsewhere. That is by filing the appeal, not here. We cannot entertain this appeal. That is their submission.
Lordship may grant 2 days time.
Okay, we are keeping this day after tomorrow.
You have obtained a stay order from this court, stay of the proceeding, and so that therefore you have to.
So,
12-11-24 रे स्टेज कराइछि 12-24
but ultimately, once that essay is disposed of, it will be decided ultimately that because you are the auction purchaser and but at your instance the stay has been granted. But since it is for more than a year now, we are to
Over 24.
year has been passed and essay could not be disposed of because the stay order has been granted. No? Yes.
We have changed. We have changed. And we have taken note of this Bafna Motors and all.
The Rasu can also dispose of the matter, whatever their grievance matters, it can be also considered by the DFT in seminars.
Lordship, if your lordship kindly, this matter may be taken up
No,
tomorrow.
he wants his senior to present, otherwise you will be misunderstood. Okay, they have put up this matter day after tomorrow. I'll spread there by the land council. Yes.
You also prepare. If your senior doesn't come, then you can argue.
Yes.
Item 27.
Yes, Mr. Rautray. With a Union of India. Acha, next matter document.
Item 28.
On behalf of Mr. Shubhankar is on his legs.
On behalf of Mr.
Shubhankar
Rao.
Shubhankar Rao.
He is on his legs, so he has requested me to
Day after tomorrow, you would have day after tomorrow. Separate 29.
Item 29.
In this case, my lord, I'll have a glance on noting. Copy not served, my lord.
I'll serve a copy in process.
Which one?
28, IA number 20917 of 2025 for amendment.
28 level. You are supposed to file an interim application there.
Yes, that is they have filed.
They have filed.
Filed, but copy not served.
Copy not.
An additional affidavit also copy not.
The Land and Council for the petitioner, Mr. Swansu, appearing on behalf of Mr. Durga Prasad Nondo, submits that he has already filed an interim application to RA the Tahsildar Tangi Chaudhar Jagatpur Cutter as opposite party number 4 in the cause title of the petition in place of Tahsildar Cutter. And they say IA has been registered as IA number
20917.
20917 of 2025. The London Council for the State, however, submits that the copy of the interim application has not been sought.
As well as additional affidavit filed by the
and moreover, one additional affidavit has been filed by the petitioner, and the said copy has also not been served on him. Land Council for the petitioner submits that he will serve the copy of the interim application, so also the additional affidavit filed by him to the Land and Council for the state within 2 days. You know, this matter next week. Yes.
Your Lordship, item number 29 on 27 November, we have filed a counter.
We have not supplied the copy.
Yes, sir. 2 days back, I have received the copy of the contract. I filed a reply to that.
You want to file reply?
I filed a reply.
The counter affidavit as the opposite party, you have filed the counter for opposite party number
2 and 3.
2 and 3.
It's a preliminary counter affidavit filed.
Preliminary counter affidavit has been filed by the opposite party number 2 and 3, which is on record. The Land and Council for the petitioner submits that he has received the copy of such a preliminary counter affidavit and intends to file a rejoinder to the same, and the matter may be taken up
next week.
Next week. Place this matter on 10th December 2025. Oh.
Item 30.
And maybe pardon to me. Your Lordship, item 26 is the interim order to be confirmed. The interim.
That is there. That is the reason you are seeking time. That will be there.
But it will be taken up day after tomorrow.
Your Lordship.
Interim order to continue till next date. Yes.
Item 30.
30.
Petitioner has filed a writ application. The writ application has been filed challenging the SAT's order, Your Lordship, 17/10/2016. The entire grievance is whether the promotion granted to respondent number 4 there, whether it is legal or not.
It needs hearing.
Nobody is present.
Counter has already been filed.
It's regarding seniority.
No, Your Lordship. Petitioner says
Any
he
stage
should-
operating.
Yes, Lordship.
So,
He should have been given promotion in the place of respondent number 4. And in paragraph number 5 at page 57, the tribunal has given its judgment regarding why respondent number 4 deserves a priority over the petition.
So where is the council? Dinesh Kumar Panda, G. Sinha, A. Mishra, and Swamjit Raut and S. Mahanti. A Swamjit Raut Buriagon Pore intercolleague appearance.
Panda. I will intimate Panda.
Oh, no objection file कर दी जल्दी. स्वयंजीत राउत आको तो नहीं गिनते ताकर पूर्व काउंसिल करो ना रिफ्लेक्ट करिया किसी जस्टिफिकेशन नहीं लकी जन since Mr. Swamjit Raut and Smruti Raut Smruti Mahanti have filed Vinama after obtaining no objection from the earlier engaged counsel. The name of Mr. Dinesh Kumar Panda and his associate shall not be reflected in the cause list henceforth. None appears for the petitioner. The land council for the state submit that the pleadings are complete. तांकु टी जाने देवे तांकु हाँ स्वयंजीत का राउत का नंबर नंबर पे थी कौन आयो ये नहीं मोबाइल नंबर कौन जाने देता so ताले next week to review this matter on 10th of December 2025. Pass over which is that one.
Pass over item number 27.
27.
None appears for the next week नहीं जाना.
May pardon for mentioning my lord. Out of list criminal appeal 830/2017 my lord. Earlier listed before your lordships on date commencing for 10/11/2000 matter will be listed, but unfortunately the matter
Please. I don't want to mention my lord. These are 3 criminal appeal my lord challenging the conviction order. I has been filed for bail my lord.
Appeal bail में 11
mention for interim bail.
Appeal bail my lord 14 years inside jail custody.
Condemnation delay ma'am. Criminal appeal.
Only but on item 43 in the board, mother of the person has been expired, may can be taken as.
I need to interception on Which number item?
43. Last Friday, Mallet also kind of.
Just. It is criminal appeal number 404 of 2020. And your application is P283 of 25 for interim bail. We have not passed any order, but orally.
Yes.
There is no order, madam. No order was passed. Just
I was just checking the IA.
The IA is 3283
Flag
of 25, and the ground has been taken that death has taken place on 27/11/25, and the death certificate, of course, it has been issued by Sarpanch. That is annexed as one.
Medical report, my lord, which has been.
So this is a local man.
Local man.
So we will ask the trial court to verify through the IIC
subject to
subject to verification. If it is found to be correct, why will keep it pending here?
May I pray? It has been taken by other additional standing counsel or AGA, my lord. Prasim must have got the instruction because it has been supplied to Mr. Partha Naik on the relevant day, and he has taken the instruction.
Phone कर दियो तो यदि आसिले दी मैम
then you call him if you
yes madam.
Weekly daily, second half, item 1.
This is PSCL application. Under section 302. Rigorous temperature for life.
What is your good name?
Kamal Hati. KM Hati.
You are in practice since 2024. Achha. Now 302 IPC is there.
Yes, sir. Yes, sir.
IPC is still there.
Yes, sir.
No. We are asking a general question whether the Indian Penal Code still exists or it has BNS. So what is the corresponding section of
103? 103.
Right. Admit call for the trial court record. Interim application for bail and stay relation of considered after receipt of the trial court record. Land counsel for the appellant shall supply the deposition copies of all the witnesses to the land counsel for the state. It is a hard Mr. K.M. Gandhi, land counsel for the appellant. Yes.
Item 2.
Item 2, my lord, the appellant convicted under section 302 for life, and there is also fine.
only or some other offenses?
Other offenses are there.
201 and 120.
201 and 120B. IPS.
Trial court record. The rest of the order is sent. Yes, next.
Item 3.
This is the jail criminal appeal.
No, conviction wrong.
302 life. 70 days of delay, that delay may be punished.
Delay कौन कर देगा? Admit कर देगा, serially करेंगे जो division का जो
Item 4.
Jail criminal appeal.
नहीं, offense.
302 IPC for life. 527 days of delay.
Chairman.
Item 5.
The imprisonment for life and fine of rupees 2,000. Here, this appellant is in custody, my lord, since 2010. That is from 9 to 2010.
And bail applications were earlier rejected.
Yes, my lord.
23/15 and 27/9/2019.
Your lordship was pleased to allow my interim bail application on the ground of my lord death of my mother, and then accordingly this present petitioner surrendered on 18/1/2024, and in the meantime
the last time
That during the interim bail period, that whether I have misutilized the liberty which has already been granted to me. That instruction was short.
And what is your period? Detention
Period, my lord, since 2010, my lord, that is custody, my lord. That 9 to 2010. Our interim period only for 2 weeks. Then he surrendered in right time. 2010 custody. I have also filed the dead checks. In dead check, my lord, I have mentioned all the date and events. 9 to 2010.
Madam, and also regards to order dated at 27/25.
It account is
On that date, madam, that
Appellant number 2 died, huh?
yes, that certificate, Hima
Singh died.
Order dated 23/7/25.
the Land Council for the state, as per the order dated 23/7/2025, has produced a report from Deputy Superintendent in charge Bangri Police OC Police Station Mayurbhanj that appellant number 2, Hima Singh, died since 14/8/2018 and in connection to the such death, the relevant document has been annexed to the report. The documents filed by the Land Council for the state are taken on record. Since no near relatives of this one, so that appeal updates so far as appellant number 2, Hima Singh, is concerned. This is one aspect, but what about the interim bail application which has been filed? That is IA number 1712 for the other appellants. There are, as it appears, 3 appellants.
1 and 3 by letting Bishop C 11.
But they have obtained the conduct. Actually, appellant so they're not involved in except. No, that we know. No, actually, not arbor. So what period you are saying you are in custody?
My lord, I am in custody since, my lord, 9 to 2010.
You have custody certificate? No.
Yes, I don't have custody certificate. And for so far as I know answer 1/2/25, there is no IO copy with me. And there is no deposition copy. They are not subtitled.
No, not
Custody
of deposition. Custody certificate. You give a copy of that thing. IA number 171 to Dina.
I got again out of the way.
IA number 1712 of 2025. This is an application for bail of appellants number 1 and 3. The Land Council for the petitioner submits that both the appellants are in judicial custody for more than 14 years. And they were directed to be released on
course of the day.
Released on bail
Deposition copy also.
for a period of 3 months from the date of release as per the order dated 25/9/2023 in IA number 1950 of 2023, and after availing the same, they have surrendered at right time. The Land and Council for the state has produced a written instruction from that the two appellants have not misutilized their liberty while an interim bail. The Land Council for the appellant shall serve a copy of the interim application.
Already saw, my lord, and deposition already saw.
Serve the copy of the interim application along with the deposition to the Land Council for the state, who seeks some time to produce the custody certificate. This matter on 8th of December 2025. Custody certificate we obtain in the meantime.
One, that item 43, my friend is already approved.
The number item?
43 again.
IN number, that is item number 43. IN number 3283 of 2025. There is an application for interim bail on the ground that mother of the appellant expired on 27/11/2025, and to perform the obsequies ceremony, the presence of the petitioner is very much necessary. Death certificate issued by the Sarpanch Sapada have been annexed to the interim application. Land Council for the state has also produced a written instruction dated 1/12/2025 from IAC Pittsburgh Police Station, which also shows that the mother of the petitioner died on 27/11. The aforesaid written instruction is taken on record. During the submission, the government taken in the interim application, the documents annexed thereto, and the instruction obtained by the Land Council for the state. We are inclined to release the petitioner on interim bail for a period of 2 weeks from the date of release. While on interim bail, the petitioner shall not indulge in any criminal activity and shall not try to come in contact with the family members of the deceased. Violation of any terms and conditions shall entail cancellation of the interim bail. Free copy of the order be handed over to the Land Council for the state, which will be forwarded to IIC, Fifth Police Station, urgent certified copy. Matter be listed on such and such date. The Land Council for the appellant shall file the surrender certificate. Yes, next.
May be in court of the law.
Yes, sir.
Item 6.
May I please, Lord, please. This is the bail application for appellant number 1, my lord. My lord, he is in custody 11 years, 6 months. My lord, earlier through occasion,
who is appearing for the informant
in
Arijit Mishra, S.K. Jena, S.K. Bishwal, A.S. Raut, and R. Mohanto. Nobody is there. Okay, your IN number is 716 of 2025.
My lord.
So This case is filed by appellant number 1.
1, my lord. 2, my lord, already released by this one.
So your bail application was earlier rejected on merit.
Earlier rejected, my lord, 2 occasion interim bail
It is mentioned in that it was rejected on 29/11/22 and 8/8/24. So the last time it was rejected on 8/8/24.
8. And honorable court also was pleased to grant interim bail about 10 weeks and first 8 weeks. And thereafter, last in the month of
You was granted interim bail twice. On what date?
Twice, my lord, 8 weeks in the first time.
Kete could order date?
29/11/22. 29/11/22.
29/11/22 रे आपको दिया इतना 8 weeks.
My lord.
तापरे next time?
Then, my lord. Order number 88/2024.
8/8/24 is second time bill.
Second time interim 10 weeks. Withdrawal.
नहीं तापर 8/8/24 second order पर 8/8/24 beat order second page रे.
My lord.
He was granted 10 weeks.
10 weeks.
So what is your period of detention?
Total 11 years, 6 months.
Have you got the custody certificate?
Already he was last in the month of August furlough.
And we just want to that custody certificate. And what about his conduct while he was gone on interim bail twice?
He has surrendered in time.
Surrender is no problem, but you kind of put
it is next week.
Item number 716 of 2025 is an application for interim bail filed by the appellant number 1, Shamogana Sahu. The learned counsel for the petitioner submits that the petitioner was granted interim bail twice. That is I'd order dated. That is for a period of 8 years. My order dated on 30/11/2022 and for a period of 10 years as per order dated 8/8/2022. And after availing the interim bail period, he has surrendered at right time. He further submits that the custody period of the petitioner would be more than 11 years. Learned counsel for the state seeks some time to produce the custody certificate, so also to obtain instruction regarding the conduct of the petitioner during the interim bail period, so also his jail conduct.
Jail conduct.
Please this matter on 8th of December.
Let the complete equation copy, Mishra. Equation copy.
I pardon. Last occasion, he was also granted furlough period of 12 days. He has also surrendered. That certificate is with him.
That's right. Let it come.
Yes.
Next.
Item 7.
Whether the appellant is insert the custody since 16/11
Then the prisoner's petition
Yes, ma'am.
for engagement of Mr. S. Samantrai
Yes, ma'am.
in place of Mr. Amulya Ratnakonda. What is your good name?
Sushant Kumar Samantrai.
Acha. Here is the prisoner's petition. Wherein request has been made for engagement of Mr. Sushant Samantrai You have filed your V now?
Yes, my lord.
Mr. Sushant Kumar Samutra and his associates have filed Wakalatnama which is accepted. The name of Mr. Kahaka na katibo Amulya Ratna Panda. How can na katibo? A Panda.
ए पन्ना मैले ରହିବ
Raibo.
ଆଜ୍ଞା ଖାଲି ଅମୂଲ୍ୟ ରତ୍ନ
ଖାଲି the name of Mr. Amulya Ratna Panda shall not be reflected in the cause list henceforth. ହେଲା ଇଏ ଗଲା ତାପରେ ଆସନ୍ତୁ ଆପଣଙ୍କର bill file କରିଛନ୍ତି IA number 339 of 2025. So it seems that your bail application was earlier rejected on 26/6/2023. Now how many years you are in custody?
My lord, 11 years, 16/11/2000.
Have you got any custody certificate?
No.
Bring it.
Position copy and
IA number 339 of 2025. ऊपर तो सीधा लिखते थे business petition को. Mr. Samantra, SK Samantra, land counsel for the petitioner, and the petitioner is in judicial custody for more than 11 years.
Yes, ma'am.
11 years. The land counsel for the state seeks some time to produce the custody certificate. So also the conduct of the petitioner in jail. You are never released on bail.
No.
List this matter.
My lord, deposition copy may supply.
As me give, take it on the 8/12/2025. The land counsel for the petitioner submits that he is not having the deposition copy. So also the land counsel for the state. Appellants also the land not having the deposition copy. Let the registry allow the land counsel for both the parties to obtain the deposition copies of the witness in their respective pen drives. Pen drive yes, next.
Okay.
8 तारिख रहुची आनिवे कस्टडी सर्टिफिकेट 11 वर्ष कोन रहिलेनी
दीटा जेल रे अछि
हां
जाजपुर एबे 14 रे अछि प्रेजेंटली
14 मगे जो से सा कोइ जो कलेक्ट करी ने से दीटा रिपोर्ट कंपाइल कर दे दो. Yes, next.
Item 8.
Yes, Mr. Sahoo.
On behalf of Share Family, Western State was instructed to obtain conduct certificate.
What's that?
Western State was instructed to obtain conduct certificate.
ଯାଇଥିଲେ କି interim bail ରେ?
Yes, interim.
Yes.
କୋଡରେ ଯାଇଥିଲେ? 18/3/25.
18/3/25.
90 days ପାଇଁ ଯାଇଥିଲେ.
90 days.
How many years you are in custody?
About 10 years.
Custody certificate. এটা কেবে করে এটা? 1/9/2025.
3483 days.
ये हिसाब करते हैं जी?
1/9/15.
9 years, some 9 years, 8 months.
No, 8 months.
3/4/9/3 लिखा है 8/3 କିନ୍ତୁ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଟା ହଉଛି ଡେଟ୍ ଟା ହଉଛି 29 ଦବୁ
9 months, 6.
ହଁ
9 years, 6 months.
ତ ସେଇ 9 years କେତେ ହବ?
9 years, 6 months.
ଦେଖି କଣ୍ଡକ୍ଟ ସାର୍ଟିଫିକେଟ
3483. 3483. Eyewitness there, we don't do. Eyewitness, we don't do.
No, we are granting him bail because of this pendency is one thing. The second thing is not misutilizing the liberty and so that's a relative case covers
3 months you had already
land counsel for the petition, land counsel for the state, land counsel for the petitioner has produced the report from the IIC Karanjia police station dated 14/9/2025, which shows that during interim bail period, Nothing adverse was reported against the petitioner. The report is taken on therefore. Stop. When counsel for the petitioner submits that the petitioner is in custody for more than 9 years.
9 years, 5 months.
9 years, 5 months. The custody certificate also indicates the same. Stop. If submits that since there is no chance of early hearing of the criminal appeal and the petitioner has not misutilized the liberty while on interim bail as per the earlier order dated 18/3/2025, he may be granted bail. The Land Council for the state opposed the prayer for bail, considering the submission made by the Land Council for the respective party. Keeping in view the period of detention in judicial custody, the principle laid down by this court on the case of Letty versus Swan and the report furnished by the Land Council for the state and also absence of any chance of early hearing, we are inclined to relieve the petitioner on bail, shall not indulge in any criminal activities, violation of any terms and conditions, or until cancellation of bail allowed. Yes.
Item 9.
Sir, you give your name and counsel. Please give it in writing. Swan R. Swan on behalf of Mr. Chittaranjan Shah.
By order dated 25th August, your lordship called for report on the conduct of the appeal.
You have granted interim bail.
My lord.
I didn't order.
Once for 4 weeks, once for 1 week, orders dated 26/2/2020 and 28/3/2020.
26/2/2020.
My lord.
That is for a period of
4 weeks.
4 weeks. Tapare
28/3/25.
23/25. Kete din?
1 week.
1 week.
Funeral.
No, that is second time on the ground of
Death of
obsequious ceremony of the deceased widow sister.
Custodial detention is around 8 years. Custody certificate is there on
there.
Yes.
Yes. Today I am also supplying the instruction as well as the custody.
Seven years, 11 months, 8 days. So, inside jail conduct is always putting a lot of past dates depending of process of deformation. Jail aguru Mr. Panda rejected like
no, on merits rejected.
last time to very merit.
FTVC
3/22.
Last time 31/3/22.
তারপরে 13/10/23।
13/22/13/10/25।
23
years.
Right.
Case under 302.
Yes. 302 read with 34.
Single murder.
Yes,
what is the weapon of offense?
Weapon of offense is one Tamil Honda, which was recovered after 2 years of the incident.
Eyewitnesses are there.
They are all inmates. They are all relations, family members of the deceased.
PW4, my lord.
PW4.
Paragraph 3.
Widow is there, sister is there.
Paragraph 3.
How doctor ki hai PW?
Doctor, my lord, PW10.
Or the land counsel for the petitioner, land counsel for the state. Land counsel for the petitioner submits that the petitioner is in.
Petition number 2, petition number 2.
Achha, it appellant number 2 by file. This interim application has been filed for interim bail of appellant number 2, Babuli Shah. What happened to appellant number 1?
He took away consent from him.
Achha, appellant number 1, Babuli Shah.
Bail pay Mr.
Pandal and counsel appearing for the petitioner submits that the petitioner is in judicial custody for 7 years, 11 months.
7 years,
7 years, 11 months.
The
land and counsel for the state has also produced the custody certificate. Stop. To that effect. Stop. Mr. Pandal and counsel further submits that the petitioner was granted interim bail for a period of 4 weeks as for law dated 26/2004 and for a period of 1 week as for order dated 28/2025 and he has surrendered at right time after availing the interim bail period. The land and counsel for the state has produced the report dated 23/10/2025 of IIC Rasol Police Station, which indicates during the interim bail period, nothing adverse was reported against the petitioner. He has also produced another report from Superintendent District Jail Denkana, which shows that the petitioner is repenting a lot for his past deeds and is in the process of reformation. The reports produced by the London Council for the state is taken on record. The London Council for the state, however, submits that on merit,
the deceased has sustained 10 injuries.
Just on merit, the bail application of the petitioner has been rejected as for order dated 31/2005 and 13/10/2023, and eyewitness PW4 has stated about occurrence, and the doctor that dated PW10 has stated has conducted the postmortem examination and noticed number of injuries
10 number
of person of the deceased. Stop. Considering the submission at the London Council for the respective parties, the nature of evidence available on record, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention and his conduct during the interim bail period granted earlier, we are inclined to release him on interim bail for a period of 3 months. While on interim bail, the petitioner shall not indulge in any criminal activities. Violation of any terms and condition shall entail cancellation of bail. Matter to the state 3 months after. The Land and Council for the petitioner shall produce the surrender certificate. Mr. Panda, you will not appear for appellant number 1.
No, he has taken consent.
Achha, has he engaged some other counsel?
Yes.
Because
his name appears in notes, Mr. Vijay.
Okay, then it's all.
Is there an application filed by him?
Prisoner's petition filed by
Bail application.
No, bail application which filed.
bail application.
One. There is no bail application.
No. Yes, next item.
Item 10.
One thing.
Yes.
Order of actually petition is for bail, interim bail.
Okay, petition is for bail. 3 months bail for appellant number 2, Naida?
Only 2.
So the one of the last paragraph, the appellant number namely so and so on, please. Yes, next item.
Item 10.
May I presume? Madam, I have already filed the comprehensive affidavit, my lord, regarding antecedent, and that was called for.
My lord, I have obtained the report, my lord. The comprehensive report, affidavit, paragraph 2 IV.
Comprehensive affidavit of RCL. Paragraph
2 IV.
Only court PS case number 162.
Commission offense. On the said case, the applicant has not been remanded till today. On the said case, having no knowledge about the involvement of applicant in the said case. I'll have a glance to the report. The applicant remanded it in that case on
who paragraph?
Paragraph 4.
Charge sheet number 8. 162. अच्छा कौन हला? The accused persons या ना कौन?
Santosh
Maran have been remanded in this case. अच्छा 8/8/2016 in the charge sheet submitted also. अच्छा taken on remand, all right. तापरे कौन हला status विषय आउ कौन इतले?
ये status कौन?
केस ला ये टाला ट्रायल ପାଇଁ ରହିଛି आरटा भी ट्रायल ପାଇଁ ରହିଛି आठटा acquittal ହେଇଛି ଆଉ fourth ଟା pending ଅଛି.
Yes. You can have glance to the order dated 12/8/2024. The bail application of the petitioner was rejected. Learned counsel for the state, on the other hand, produced the report received from the inspector in charge High Court Police Station, which indicate that apart from this case, 4 cases have been instituted against the petitioner. One of the cases.
What is the detention period?
More than 10 years. And other co-appellant has been released on bail. For co-appellant.
There also we have mentioned it to be 9 years, 6 months.
Now, earlier rejection order in the month of August 2024, more than 1 year.
So obviously he has remained in custody for
more than 10 years.
But you are an absconder.
Yes,
and you was apprehended at Nagpur.
And gave recovery
about 1 year so and so.
And that was your lordship has taken into consideration that one of the condition that while he was on parole has committed another offense. In that case, has been acquitted, madam. That he 2,400 has been taken. That I was doing the acquittal order.
No, acquittal may be on various grounds, but the fact that when you are granted interim bail,
not in parole, my lord.
In parole, parole false case
and the deceased younger brother of an advocate.
Father expired, my lord. Mother is alone in the village, my lord. At this juncture, my lord, he will be diligent, my lord. That is, my lord. Mother will be, my lord.
My lord, here it is, my lord.
He is the principal accused. He committed the crime, my lord.
No, my lord. No, I am not the principal accused. Principal accused is please Samsundar Kusti, my lord.
The counsel for the state has produced the reply to the comprehensive affidavit filed by the petitioner, which is taken on record. The matter will be stated in the February 2026. Yes.
Item 11.
He is convicted under section 302 of the IPC and sentenced to undergo imprisonment for life and pay a fine of 10,000 lordships. The picture is custody since 6/6. Apparently, custody since 6/6/2017 lordships. And earlier this bail is rejected on merit. That is on workshops
by Shivar Dwejar Vice.
Yes, workshops.
Now,
And
about your, what is the period now?
more than 8 years also. And during
Maybe that
two times he has been released on interim bail also.
Not confirmed.
by this court.
Yes, Your Worship.
Tell us the dates.
On by 12/2022 for a period of 12 weeks, Your Worship. On 22/12/2022, he was released on interim bail for a period of 12 weeks. And Your Worship's 27/4/2022, released on interim bail for a period of 1 month. Your Worship. And he has been surrendered in the right time.
27/4/22 ଦିଥର ଯାଇଛନ୍ତି।
ଆଜ୍ଞା। He is surrendered in right time, Your Worship.
The petitioner is the husband and yes of burning.
To permit me, file a tax chat, prepare tax chat. Your Worship.
Where is that custody certificate?
Not option.
Custody certificate.
Manner.
Bring it. IN number 2646 of 25. The land counsel for the appellant submits that appellant is in judicial custody. କେତେ ବର୍ଷ ରହିଛନ୍ତି କହୁଛନ୍ତି?
More than 8 years.
For more than 8 years. And he has been granted bail in bail twice by this court during pendency of this appeal. That is for a period of 1 month as per order dated 27/4/2022 and for a period of 12 weeks
22/12 bites. That is 22/12 bites.
as per order dated 22/12/2020 and surrender at right time.
Yes, Your Worship.
After availing the interim bail period. The learned counsel for the state seeks some time to produce the custody certificate as well as the conduct of the petitioner while on interim bail and also his jail conduct. Put up this matter on 8th of December 2025. Yes.
Item 12.
Yes.
Last occasion, my lord, custody certificate, obtain custody certificate.
State to produce custody certificate. Yes. Appellant number 1. Your bail application relates to appellant number 1.
My lord.
But another has been filed for appellant number 2 also.
My lord.
You have filed both the interim application.
My lord.
So is it available that custody?
Yes.
One or both is available.
Hemant Luhadga Magai.
Amount of time, acha, is the number 1.
1.
You have not obtained the for number 2.
No.
Lady. The she is a lady here. How many years in custody?
11 years, 8 months.
What is the case, prosecution case?
The lady with her farmer killed husband.
Ladies paramour.
Bail application was earlier rejected. ଲେଖା ହେଇଛି କଣ ଗୋଟେ earlier rejected ବୋଲି 23/7/2024 ରେ but you are granted increase though. 3 months granted.
Invalid rejected. Appellant number 2.
No, appellant number 1 ro bail grant ହେଇଥିଲା ନା
Interim bail minor.
interim bail. So what about the conduct?
Conduct I will, my lord, often.
The land counsel for the petitioner, the state has produced the custody certificate of the appellant number 1. The नाम लिख दियंतु हेमलता लोहारी. एटा होची लिखिवे IN number 2737 of 2025. And the same is taken on record. However, the land and counsel for the state submits that since the petitioner was granted interim bail for a period of 3 months, as per the order dated 23/7/2024, he may be given some time to obtain instruction regarding her conduct while on interim bail. Put up this matter on 8th of December 2025. 8/12/2025, the land council shall obtain, state shall obtain the instruction regarding the out IN number secondary for them to custody certificate produce kariya lagi है ना. अलगा अलगा किन करिबा.
Item 13.
May I please your lordship, my lord, order number 7, last occasion, my lord, IN number 3189/2023. My lord, second para re one reject ହେଇଛି, my lord, କିନ୍ତୁ କୋର୍ଟ ରିଫ୍ଲେକ୍ଟ କରିଛନ୍ତି 2 ଥର ରିଜେକ୍ଟ ହେଇଛି. IN 472 ସେ ଫାଇଲ IN 473 my lord ରିଜେକ୍ଟ ହେଇଛି. କିନ୍ତୁ my lord wrongly typical mistake 29/8/23 ରେ IN number 473 23 ରେ ରିଜେକ୍ଟ ହେଇନି my lord. ତାଙ୍କ ଘର ଲୋକ ଅନ୍ୟ 3 ଜଣ ବେଲ ଯାଇଛନ୍ତି. यार भूल रंग टाइप ହେଇଛି मैडम. One time reject ହେଇଛି मैडम. 2 time not reject. ଆଉ affidavit मैडम फाइल कर ଦେଇଛି. 376 IPC against 10 years already undergone. कठोर सेक्रेटरी मैंने affidavit फाइल कर.
Flaggy. Custody certificate flaggy. 12 years left. But what it appears that he was having one criminal antecedent and the offense which has been mentioned there, that he faced a trial under section 376 and he was also found guilty and he was sentenced to RI for 10 years. So we wanted to know whether any appeal has been preferred and if so, about the status of the appeal. And an affidavit is to be filed. And the affidavit has been filed by one Abhi Behera. As mentioned in the affidavit, what are the election? whether any appeal is pending.
No, ma'am. This was Honorable Justice Biroja Prasad Sattpathy court
We are
order
asking
number
you.
9 dated 12/9/25.
बुझा पड़ेगा.
Order already filed.
Has been preferred against the conviction which has been under section 376.
Appeal file is ma'am. CRL 136 2016. 2016. Order already filed, ma'am. Order number 9.
1 minute, please.
Yes.
It requires status report in criminal appeal number 136 of 2016. Devotion to Shilha. What is
The number of the criminal appeal is 136 of 2016.
Yes, madam. Order number 9, order 12/9/25 already disposed. Honorable Orissa High Court.
What has happened in that case?
What happened in that appeal?
Sentence already undergone, my lord.
10 years
At the bar criminal appeal.
Custody certificate already filed, madam.
RI for 10 years completed.
CRL number होची 136 ଆଉ ଇଏ ରହୁଛି 2016. क्लिक करो. जजमेंट के पेज देखो. Not proceed to appeal. Contenders in the appellant has already undergone the sentence.
No.
He does not intend to proceed with the appeal any further, and appeal be treated as not fair. The copy de bhar
Copy already filed, certificate copy filed.
So you have filed that criminal appeal order. So now the custody is more than 12 years.
30 years.
What is the offense here?
302, 34,498.
Reject it now, 323. Mr. Pradhan, his bail application was rejected earlier on 29/8/23.
29/8.
But he has remained in custody for a period of more than 12 years. So we are granting him interim bail for 3 months. We are watching his conduct. We'll see that. As per the order dated 3/9/2025, the London Council for the petitioner has filed an affidavit which shows that challenging the conviction order, he preferred criminal appeal number 136 of 2016 before this court, which was disposed of on 12/9/2024 as not faced, as the petitioner had already undergone sentence awarded by the London trial. The copy of the order has been annexed to the affidavit. Stop. Land Counsel for the petitioner submits that the bail application of the petitioner was rejected on merit by order dated 29/3/23.
29/8
on Christian 2023. And the petitioner has remained in custody for more than 13 years. The custody certificate, which is dated 25/8/2025, indicates the custody period to be 12 years, 11 months, and 25 days. Considering the submission made by the Land Council for the respective parties, period of detention in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on interim bail for a period of 3 months. While on interim bail, he shall not indulge in any criminal activities, and violation of any terms and conditions shall entail cancellation of bail. Matter be placed after 3 months. Land Council for the appellant shall file the surrender certificate. Hello? So 3 months bail granted. Yes, next.
Item 14.
Mr. Maharana.
And the present appellant was granted interim bail for a period of 3 months.
Kebe, Pujan.
15/5/2024. And the surrender in time, Lordship, and producing certificate.
What about its conduct? I would have well filed conduct anantu. Chandi. Click on the Land Council for the IN numbers also. This is an application for bail. Land Council for the petitioner has filed the surrender certificate, which is taken on record. The petitioner was granted interim bail for a period of 3 months, as per order dated 17/5/2022. Let the Land Council for the state produced a report relating to the conduct of the petitioner while on interim bail. Who thana? Judgment Pottangi police station. Yes, next. 15/12/2025. Free copy of the order be handed over.
Item 15.
Surrender certificate taken on record for this.
Please, my lord.
Yes, Mr. Pandit.
My lord, here the petitioner is languishing in jail custody since 22/4/2019. The unfortunate incident has happened, whereas the deceased and also the petitioner, they are coming in one bike and also
Bail,
the,
have you rejected?
yes. It was 21/8/2022.
Just a minute.
21/8.
2023 rejected.
Again.
What is your period of detention?
More than 6 years. One pelting each other.
Rejected also. How come there criminal antecedent?
Nahi, kichi nahi.
Report of somebody.
Anjandi.
Obtained this year.
Ketada season.
No, madam.
Jail conduct ठीक है start.
Found nothing adverse in it except this.
Our custody certificate ଦେଇଛନ୍ତି ଏଟା ହଉଛି 5 months ଏଟା ହଉଛି ଆଜୀବନ ଏଟା କେବେ କାହାର ଏଟା 17/7 ରେ ହଉଛି
17/7/2020.
ହଁ 17/7 ମାନେ ଆଉ 4 ମାସ ଗଲେ 4 ମାସ ହେଲେ ଆଉ 6 years 9 months ଅଫିସ Single murder.
Single murder.
Eyewitness ଅଛନ୍ତି?
PW6 is the eyewitness. 6 is that. Vijay Naik.
Doctor P.
14.
And Doctor PW
14.
କୋଉଥିରେ ମାରିଲେ?
Stone pelting each other. Only stone pelting.
କରେ ନା ନାଇଁ ମୁଣ୍ଡରେ
No. They are coming in a bike, but he was in intoxication condition, and for that they are quarreling each other and throwing a stone to each other.
The deceased, the accused then came over the body of the deceased, possibly gave 3 stone blows on his head. ଏହାକୁ ଛାତି ଉପରେ ବସିକିନି ତାକୁ ପଥରରେ ମାରିଛନ୍ତି 3 ଥର।
Sir, para 10 page 7 ରେ that has been
ପଥରରେ ଫୋପାଡ଼ିଲେ କଣ ଆମ୍ବ ନା ପଣସ?
possibly gave 3 stone blows on his head. When there appears no materials on record as to for what purpose the accused stopped the motorcycle or any cause which compelled him to do the same at the spot, then his motive to commit the offence found well enforced. Besides this, witness has also narrated the details of the incident which happened in his presence between the accused and the deceased on that day. His evidence further goes to show that both came in push and pull by inflicting fist blows to one another, to which he intervened.
7 ବର୍ଷ କମ୍ପ୍ଲିଟ୍ ହେଇଛି ବର୍ତ୍ତମାନ ହଉଛି 6 ବର୍ଷ 9 ମାସ ହଉଛି ଫେବୃଆରୀ। Counsel for the has produced the report from the IIC Model Police Station Board regarding the criminal antecedent, which is taken on record. It is this matter in February 2026. Yes, next.
Item 16.
My lord, on behalf of Mr. Senior Counsel, ill my lord, matter adjourned today, my lord.
Senior Counsel.
Why that is appearing in this case, my lord?
कहाँ पाई?
In connected matter of
Sub item. Come forward. Please come forward. अच्छा जो criminal appeal 758. Mr. Rotho, you are appearing for informant.
Lordship can have that order dated 7th of May 2024 of the Honorable Apex Court. Well, that matter, that order at 18/3/2025. That's why can have that order.
Which one? Which matter?
Which one? 8 order dated
Flag 10.
like
423
Yeah. Flag bail by this code of 9/10/20.
Yeah, this code at flag X CRL.
Oh yes, ma'am.
Sir.
Bail was granted on 9th October 2023.
Yes, sir. Which order was challenged here? That before the
9/10/23.
19/20/23.
Yes, ma'am.
One of the order is
Granted
Bail
bail.
cases, bail grant, right.
submission made. So, on for your question.
Could always paragraph 4 would be relevant. Page 4, last paragraph.
The appellate court is inclined to consider the release of the convict sentenced to imprisonment. for
The interim bail was extended up to 15/5/2024 and a fresh consideration is required thereafter.
Then the matter was hard. The order was reserved, but unfortunately, the concern beings man of justice then retired. After that, it is
तो objection file होगा
file की sir.
हाँ ऐसे file ही थी
Again, both the state and the informant both have filed it.
अच्छा तो copy दे दीजिए
No, I copy the
Replied to the response given by the state and the informant. Petitioner has already replied.
Yes.
No, madam.
One is
Last
at flag
one,
G and one is flag B.
18/3/2025.
Reply.
There are two, madam.
Now what further you want?
And for the criminal appeal number 629/2020. No objection are supplied to me till date.
हाँ objection दे दो ना तो objection.
They had not supplied the copy of the.
No, the problem is that the interim order which was passed, it was till a particular date. That period has expired since now. Because the interim order, as it appears from that Honorable Supreme Court's order,
They've been taken into custody.
No,
First, they have taken into custody. Order does himself.
because it was granted till 15/5/2020.
But then that is the order of this kind.
on 15th, your lordship can have that order dated 15th of May. It's so. Order number 7. Bail granted to the appellant by order dated 9 shall continue till next date. Paragraph 4.
Who order?
Order dated 15th May 2024.
Yes, that is.
But it's granted in respect of in IA 926.
The bail granted to the appellant by order dated so and so shall continue till that date.
Next.
So it
is on that basis it is coming.
नहीं.
This order won't challenge.
No one. No one.
Your Lordship may see the Supreme Court's order.
We have seen that.
Thereafter, my lords, this court has granted, allowed them to continue.
Item number 96 of March is an application. So, okay. Here will be properly. That is specifically observed that if specifically observed as for the scope in the circumstances once. So in some sentence. The state order was passed on
7/5.
The matter was taken up on 15/5/2020 by ruling at bench. And the favor of the applicant by order dated 9/10/2020 passed in IL number 926 of 2023 was directed, which was set aside by the Honorable Supreme Court, was directed to continue till the next date. Which is under the matter was directed to be listed on 28th June 2024 along with CRLN number so and so order the key and
Your Lordship, the order dated 8th of October 2024.
15/5 thereafter the matter was listed on 26/7/2024 comma 16/8/2024 6/9/2024 8/10/2024 11/2/2025 18/3/2025 22/4/2025 and was adjourned, but the bail order which was granted on 15/5/2024 till 28th June 2024 was not extended. It is told to this bench that the appellant has not yet surrendered. Let the appellant surrender by 6th of December 2025. Matter be listed on 10th of December 2025. Surrender certificate shall be produced to for consideration of the bail application. A report, a free copy of the order to be handed over to the Land Council for the state. If the appellant doesn't surrender by 6th of December 2025, the Superintendent of Police of Cuttack shall ensure that the appellants are arrested and produced before the Land Trial Court and remanded, and thereafter the Land Trial Court shall remand the petitioner to judicial custody and report to this court. Similar order may be passed in the other connected appeal to Bharatiya CRLN number 629.
Can your Lordship see order dated 8/10/2024 for a moment?
Yes, just a minute. In this 16/8/10/24.
Yes, my Lords may look at paragraph 2. While producing materials placed for addressing rival submissions, in passing the order, this court feels it apposite to take into account the conduct of the applicant during all these periods, when he has been enjoying the liberty in view of the order passed by us, which is continuing to be in force and now requires to be passed afresh, giving a relook, keeping in view the order of the Honorable Apex Court, as also his conduct while inside the jail.
Nothing has been stated about.
But the order has been continuing to be enforced.
No. Kindly see the previous order. Just see the
This
bail.
order.
No, the
dated 8/10 show.
bail granted by the to the appellant by order dated 9/10/2023 shall continue. The same order is satisfied by the Supreme. How can it be continued? Same order 9/10/2023.
But how can the court pass this order on?
No, that is we do not know. The one suppose an illegal order has been passed.
Right. That may be illegal.
Yes.
Another aspect I am asking your lordships to consider. Your lordship directed me to surrender. Your lordship may stop at that. There is no reason to direct the SP to arrest.
Yes, you will not.
The SP cannot do it.
Okay, we'll see that. Yes, next.
We cannot do it, my lord, because this is under the commissionerate police.
Yes. Yes. Next.
So that
Item
part
17.
your lordship may keep in abeyance. I surrender.
All the matters. Yes.
But your lordship may keep that part in abeyance. I surrender.
No, you surrender first.
That part your lordship.
Surrender. There is no need for the SP. Yes, because of the violation of the Supreme Court order, we are passing that order.
There is no violation.
Yes, next.
Item number 16, deposition copy may be
All the matters copy are handed over to you and carry out.
All the matters paper book is ready.
Okay, next item 17. 17.
My lord. Now the petitioner is languishing in custody, my lord, since 13/3/2016.
Yes, item 17.
My lord, the petitioner is languishing in jail custody since 13/3/2016 till today. And the custody certificate as well as the conduct certificate is
Nine years, 11 months.
Sir.
What is your conduct? Satisfactory.
Because they are quarreling each other for the collection of that tamarind.
Nothing adverse. କେବେ ଯାଇଥିଲେ ଆପଣ interim bail ରେ?
No interim bail. No.
20, 21, 22 period. Period 20, 21, 22. No. We just wanted to know at any point of time whether he has been granted interim.
No interim.
So his bail application was rejected on merit on 28/8/20.
Sir.
तापर आउ reject ହେଇନି?
No.
Part the Learned Counsel for the petitioner and counsel for the states. The Learned Counsel for the state has produced the certificate of the petitioner, which dated 8/9/2025 from the Superintendent Sub-Jail Umar Court, which shows that
submitted
which shows that the petitioner is in judicial custody for 9 years, 5 months, 23 days, taken on record. And also produced the certificate from the Superintendent Sub-Jail Umar Court, shows that the conduct and behavior inside the jail is satisfactory. The Land Council for the state has also produced the report dated 30/11/2025 of the YC Kundi police station to show that nothing adverse against the petitioner has been. This is relating to the criminal antecedent. There is no criminal antecedent. The reports are taken on record. The Learned Counsel for the petitioner submits that the earlier bail application of the petitioner was rejected on 28/8/2023. However, taking into account the period of detention of the petitioner in judicial custody, and since there is no chance of early hearing, the petitioner may be granted interim bail for some period. And counsel for the state oppose the prayer for considering the submission made by the learned counsel for the respective parties. In view of the available material on record, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention, judicial custody, absence of any criminal antecedent, the jail conduct, and absence of any chance of early hearing, we are inclined to release the petitioner on interim bail for a period of 3 months. But usual order. Yes.
Item 18.
My lord, item 18, last my lord, directed to obtain instruction regarding conduct of the appellant number 2. I seek one short adjournment.
My lord, custody certificate.
No, instruction. Conduct of the appellant highly was done interim bail.
That is there already. IIC Sasson Police Station.
Not highly with the
We have mentioned is that produce the written instruction which shows that he has not misutilized the liberty during the interim bail period. And you took time to produce the custody certificate. You have got it. There are two appellants here, and you have filed this application IN number 874 of 25 for both the appellants. Your bail application was rejected earlier.
No, my lord. In 3 months interim bail.
No, that's all right. Last time you were granted interim bail. Had order dated
7/10/2024. 21/2025 service.
7/10/24. That was a period for
3 months.
3 months. Are the learned counsel for the petitioner and counsel for the state? এটা কাহার ফাইল করছেন?
Both. Dhruva Giri Govardhan. Two
Dhruva Guru, 11 years.
Dhruva Guru, 11 years.
The appellants, which shows that appellant number 1 ro na ko Guru. These are the period change. The appellant number 1, Dhruva Guru, has remained in judicial custody for 11 years, 10 months, 8 days. And appellant number 2, Giri Govardhan Guru, Ajan 1/11/2025. And appellant number 2, Giri Govardhan Guru, has remained in custody for 10 years, 11 months, 7 days, as for the dated report, custody certificate dated 1/11/25 for a signature for the date. The reports are taken on record. The learned counsel for the state has already produced the written instruction received from IIC Sasson Police Station to show that the appellant number 2, Giri Govardhan Guru, has not misutilized the liberty while on interim bail, which was granted to him. Kebe granted diya?
7/10/2024, 21/2024.
7/10/24. And ଆଉ ଗୋଟେ କେବେ
Surrender 20.
No, no,
Surrender
surrender
One
for how to release.
Surrender ଖାଲି କହୁଛି release କେବେ ହେଲା surrender
release 7/10/2000.
7/10/20. So considering the submission made by the land council for the respective parties, the period of detention of the petitioners in judicial custody, and since the petitioner has not utilized their liberty while on interim bail and absence of any chance of early hearing, we are inclined to petition on bail allowed.
Item 19.
Appellant number 1.
For the number 1.
823 of 25. And there is another appellant number 2.
No, there are 3 also.
3 appellants.
नहीं ଦି ଜଣ ପାଇଁ ଆଚ୍ଛା ଆଚ୍ଛା 2 3 ସେକେଣ୍ଡ ହଉଛି 2 3 ଫାର୍ଷ୍ଟ ହଉଛି 1 custody certificate and picking instruction are class H and J. 3 years okay. Custody period is 3 to 4 years okay. Earlier rejected on merit.
No.
Why? Yes, they have been granted interim bail measures initially for a period of 12 weeks. Thereafter, Millards for a further period of 1 month.
ଗୋଟେ ପେଜ ର ଇଏ କରିଦେଲେ ଆମେ ଖୋଜୁଛୁ ଗଲା କେବେ ଗ୍ରାଣ୍ଟ ହେଲା କେତେ
Grant ହେଲା, my lords, may look at order dated 6/12/2023. 21/8/2024.
No, some order has been passed on 16/5/25.
Last day 16/5.
You do one thing, we are keeping it day after tomorrow. ଗୋଟେ ଚାର୍ଟ ଦେଇ ଦିଅନ୍ତୁ ଆମକୁ ଯେ କେବେ ଯୋଉ ବେଲ୍ ହେଇଛି କେତେ ଦିନ ପାଇଁ ଆଉ
Order ଲେଖା ହେଇଛି
କୋଉଠି
Your last stated that in the previous order.
previous
ଆଜ୍ଞା previous order
17/11 ରେ complaint ନାହିଁ ତ ହଁ ଲେଖା ହେଇଛି appellant number 1 was granted interim bail thrice by this court by order dated swan. So the appellant number 1 is stated to have granted parole also. So far as appellant number 2 and 3 are concerned, they have been granted interim bail. Acha କୁହାଇଥିଲା ଆପଣଙ୍କୁ conduct ଆଣିବା
ଅଛି already flag H ଆଉ J
custody certificate ପରା
ଦେଇ ଦଉଛି
এটা তো 27/10/2025 ର କଣ it is found that ଗାର କିଏ ପକେଇଲା ତା ଦେହରେ ସେ ଯୋଉ 27/10/2025 ରେ
ସେଟା ଟିକେ ମ୍ୟାଗ୍ନିଫାଏ କରିଦେଲେ ପଡିବ Accused Jitu is involved in Khandagiri PS case 276.
Oh, it's a criminal anti-injury.
11/9/95. Seta we have filed a reply. He has been acquitted from that.
Yes.
ଆଉ ଗୋଟେ ହଉଛି
ଲେଖା ହେଇଛି nothing adverse found against the accused person.
other accused person.
Flag A we have filed a matter.
But our query was to obtain the instruction regarding the conduct of the petitioner or appellants while on interim bail. It is not on the criminal antecedent. Are you not following the order?
ସେଥିରେ ଲେଖିଛନ୍ତି
କଣ ଲେଖିଛନ୍ତି
letter dated 27/10/2025 In obedience to the letter, subject cited above, I have on to submit that on verification of available PS record and CCTNS portal, it is found that accused Jitu alias Biswidar, son of so and so, is involved, but nothing adverse found against others. However, I would ଅଛି
ଆମେ ଇଣ୍ଟରିମ୍ ବେଲରେ ଯାଇଥିଲେ ତାଙ୍କ କଣ୍ଡକ୍ଟ କଣ ଆପଣ କହିଲେ ଆମେ ରେକର୍ଡ ଭେରିଫାଇ କଲୁ ଏଇ ଗୋଟେ କେସ୍ ଜଣଙ୍କ ନାଁରେ ମିଳିଲା ଅନ୍ୟମାନ ସେଇଟାକୁ ଆମେ ଚାହିଁଥିଲୁ ସେଇଟା ଦଉନାହାନ୍ତି This is so far as petition number one. Jitu alias Biswajit Das. That means he is criminal appeal. What about number two? Chief bail le jaina thila ki?
गोटिए क्रिमिनल गोटिए क्रिमिनल
appealant number one. CB ଯାଇଥିଲା ନା interim bail. ଆଜି ଆଣିଛନ୍ତି only conduct of appellant number one. ଆପଣ ପୁରା ଦି ଜଣ ଯାକ ହଁ
ତିନି ଜଣ ଯାଇଛନ୍ତି
ଜଣକର କଣ ଆଇନ
ଚିଠି କେବଳ ଜଣକ ପାଇଁ
କଣ ପାଇଁ ଜଣ
ସେ ଯୋଉ ଡେଟ୍ସରେ
ଲେଖୁଛୁ Learned Counsel for the states shall obtain instruction regarding the conduct of the appellants while on interim bail ଏବଂ ତା ଦେହରେ ଆମେ ଲେଖୁଛୁ ଯେ 2 ନମ୍ବର ଆଉ 3 ନମ୍ବର ସେମାନେ interim bail ଦିଆ ହେଇଥିଲା
next week mail time
the Learned Counsel for the appellant state has produced the report relating to the conduct of appellant number one, Jitu alias Biswajit Das, during the interim bail period from the IIC Khandagiri Police Station, UPD Bhubaneswar. However, he seeks time to produce such report in respect of appellant number 2 and 3, bracket to Chotu alias Chittaranjan Padi and Rudra Narayan Sahoo. This matter on 8th of December 2025. This is taken on record. You see, the problem is that when we are uploading the matter on the very same day, you should at least find out a copy and annex it to your file. ସବୁଦିନ କୌଣସି ଏମିତି କେସ୍ ନାହିଁ ଯୋଉଟା କି 8ଟା 9ଟା ଭିତରେ ଆମେ ଅପଲୋଡ ହଉନି ତେଣୁ ଆପଣ ଯଦି ଠିକ ସେ ଆପଣ ଗୋଟେ ପ୍ରିଣ୍ଟ କାଢିକିନି ଦେଖି ଦିଅନ୍ତେ ଏ ଭୁଲଟା ହେଇନଥାନ୍ତା ନା ଆପଣ ଜଣକର ମଗେଇଦେବେ ଆମେ 3 ଜଣକର ମଗେଇଦେବେ and that is getting delayed. ବର୍ତ୍ତମାନ ଆମେ appellant number 1 କୁ ଖାଲି consider କରିବୁ appellant number 2 and 3 ଗୋଟେ order pass ହେଇଥିଲା. It is for you why they should remain. Let us say that we decided to grant bail to appellant number 1. Why these two? What is the fault they have committed? Why they should keep custody for more 7 days?
ଗୋଟେ SOP କରିଦଉନୁ ଗୋଟେ
AG officers function that way.
ଲିଷ୍ଟ ରେ ଲେଖା ହେଇଯାନ୍ତା Government State Council to obtain
ଯାହା କଲେ ମଧ୍ୟ
etc.
highly ଯଥେଷ୍ଟ ନାୟକ ପାଖରେ ମୋ ନାଁରେ allotment ମୋ ପାଖରେ
then you have to keep your house in order. For that, why should they suffer?
ସେମାନେ unnecessarily ଏଇ matter ଗୁଡାକରେ unnecessarily କଣ ପାଇଁ ଆର୍ଜନ ହବ?
When I was sitting in Singri, I passed at least 5-6 orders. I have communicated to the
you see, we are not telling about all these things. I do not know the other council. But suppose in this type of cases, we pass an order today in respect of one appellant. I do not say that Mr. Panda will do that order. But the council used to say that, look, we
Yes,
have
sir. Yes,
granted
madam.
we have obtained
My
the
lord.
bail order. Immediately the file will be transferred from the other council to this.
My lord,
And
yes.
it is only, there is no laches on his part, but it is for this reason the brief will be transferred. So we do not want to do that
My lord,
in
my
this
lord.
time. I'm not telling that this is the case, but it happens in cases. Yes.
What happening is today, he's handling this case. Tomorrow he'll find someone else.
But he was the order to actually
The order is like, সে যে ভালো করছেন বেতন দুজন সিগনেটকে ভালো করে কেউ
Yes, next please.
Item 20.
Wait, in this appeal, appellant was custody 11 years.
In this case, my lord, last time my lordship directed to call for the custody and antecedent, my lord. In this case, my lord, that is the initially justice was submitted on the POCSO, under the POCSO Act, but the judgment come out on the 302. But
ଗୋଟେ କଥା ନାହିଁ ଆମେ ଆପଣଙ୍କୁ 8/5/2025 ଅର୍ଥାତ୍ ପାଖାପାଖି 7 ମାସ ତଳେ କହିଥିଲୁ ଯେ ଆପେଲାଣ୍ଟର କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ତାର କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ଏ ବିଷୟରେ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିବା ପାଇଁ 7 ମାସ ପରେ ଆଜି ମ୍ୟାଟର ଲିଷ୍ଟ ହେଇଛି ଆପଣଙ୍କର କଣ କରିବାର ଅଛି କଣ ଆଣିଲେ ଆପଣ ଲେଖିଛନ୍ତି ଚିଠି
ଯାଇଛି 14/5/25 ଯାଇଛି
ଆପଣ ଦେଇଛନ୍ତି ନା ଅନ୍ୟ lawyer?
ଅନ୍ୟ lawyer.
That's the problem. Keep on
ତାପରେ
changing the prosecutor and this two have to suffer.
ବର୍ତ୍ତମାନ ଆପଣଙ୍କ ବର୍ତ୍ତମାନ କଣ ଆଜି ଆମେ ଲେଖିବୁ ସେ ଏମିତି 7 ମାସ ହେଲାଣି ଦେଇଥିଲୁ କିଛି ପ୍ରଡ୍ୟୁସ କରୁନାହାନ୍ତି ପୁଣି ଆଉ ଗୋଟେ ଟାଇମ ଦଉ So most of the cases is getting urgent. It's a question of somebody's liberty. Liberty ସେମାନଙ୍କର ହ୍ୟାମ୍ପର ହଉଛି ନା ନାହିଁ ଆପଣଙ୍କର ଯୋଗୁ ଷ୍ଟେଟ ଯୋଗୁ ସେମାନଙ୍କର ଲିବର୍ଟି ତାଙ୍କର ବେଲ୍ ଆପ୍ଲିକେସନ କନସିଡର ହେଇପାରୁନି ଏଇ ଯୋଉ ଟାଇପର ଆଟିଚ୍ୟୁଡ ଆମକୁ ଆଉ ଟିକେ ସମୟ ଦିଅନ୍ତୁ ଆମେ ଅମୁକଟା ଆଣିବୁ ସମୁକଟା ଆଣିବୁ ହଁ ତ ଗୋଟେ କରୁନାହାନ୍ତି ଏଜେନ୍ସି କାମ କେମିତି କରିବ ପରଫେକ୍ଟଲି ଆନାଲାଇଜ କରିକି କିଏ ସବୁ ଫାଇଲ ଡିଲ୍ କରିବ କେମିତି ଲେଟର ଯିବ ଯୋଉଠୁ ଲେଟର ଆପଣଙ୍କର ଲେଖିଛନ୍ତି ସେଠୁ ଯଦି ରିପ୍ଲାଏ ଆସୁନି କେମିତି ଫଲୋ ଅପ୍ କରିବେ ଏଗୁଡା ସବୁ ସବୁ କଣ ଆମେ କହିବୁ ନା ଆମେ ଆର୍ଜନ କରିଦଉଛୁ ବୋଲି we know that how we can impose cost on you because you are saying somebody's life and liberty ଆପଣ ଯଦି ଏଇ ମ୍ୟାଟରଟାକୁ ଯଦି ଆଜି ଆର୍ଜନ ହଉଛି only for you why you will not pay the cost to the High Court Bar Association at least deposit something and let it be that ଏ ଗୋଟେ ମ୍ୟାଟର ହେଲେ ତାପରେ ଆପଣଙ୍କର ମୁଣ୍ଡରେ ପଶିବ ଯେ deposit ₹10,000 ଲେଖନ୍ତୁ IN number so and so for bail.
It did not hide you.
This is an application for bail when the matter was considered, when the matter was taken up on 8/5/2025. We directed the Land Council for the appellant to supply the deposition copies of the witnesses to the Land Council for the state, and the Land Council for the state was directed to obtain custody certificate
day after tomorrow
as well as instruction relating to the criminal antecedent, if any, against the appellant. You have supplied the deposition. Land Council for the appellant has supplied the deposition copies of the witnesses to the Land Council for the state. Stop. When we made a query to the Land Council for the state about the custody certificate as well as about the criminal antecedent aspect, the Land Council for the state submitted that as per the order dated 8/5/2025, a letter was written
14/5/25
on 14/5/2025 to the inspector in charge of Jagatpur police station and also to the
District Jail Jagsonpur.
and
Superintendent of
District Jail Jagatsinghpur.
But let's say now it's in Kuntuli jail.
But no response has been received. Stop. The Land Council for the state submits that the matter may be taken up next week, so that in the meantime he will obtain the necessary instruction in the matter. It is a sorry state of affair that when the matter is being taken up after 7 months, the Land Council for the state has not is not being able to produce the custody certificate as well as to obtain instruction on the criminal antecedent. In view of the request made by the Land Council for this one, place this matter on 8th of December 2025, subject to state depositing cost of rupees 10,000 in the High Court Advocates Welfare Fund. Receipt to that effect shall be produced on the next date. Land Council for the appellant has pointed out that the appellant is in Kuntuli jail. Kuntuli jail.
Model
Yes. Next.
The object fee should be with the deposit of the state. I think that is the jailer and
Somebody has to deposit. We don't know who is to deposit. Yes, next.
Item 21.
Item 21 may please follow. Let's I 3063 has been for bail. Is the subsequent on the bail application?
a copy not has been solved.
It has been solved.
They can't give a soft copy.
No, not it has been solved in the as it has been.
Why are you not keeping the documentary proof? Now, in some of the cases, they are disputing it. Proof it so that we can say that no further
online, so it is being solved.
No, you must have that proof that you have given it online.
It has been
Online filing online, but this case
online ना आपण जेबे देइथिबे तार उठे कॉपी बाहर करी आनियो ना पण online जो filing କରୁचंदी there must be something that you have filed in online. How can we accept your statement without any?
Well, similarly, because the physical copy remains with us, and the online copy for both the court as well as the AG copy is being served online through.
Yes.
That is the process.
So how can you ensure that the copy has been received? Because you are sending a document online, whether it reached the destination or not. There is no method. You mean to say that to know that whether it has reached the destination or not?
I'll give another copy.
Is rejected on 9/2024.
Earlier rejected.
IN number 3063 of 2025. This is an application for bail. And Council for the State submits that copy of the interim application has not been served. Let a copy of the interim application be served on the Land Council for the State. We shall produce the custody certificate.
Custody certificate I have
You say seal or sheet there?
Seal like signature.
No, you obtain the custody certificate. The conduct of the petitioner, criminal antecedent as well as the jail conduct. Matter will be listed on 8th of December 2025. Yes, next one. Let's see.
Item 22.
The application of the petitioner was earlier rejected.
13/8/24.
Yeah.
Yes. What is there for reconsideration within short span of time?
This is a matter relating to 376 on SCST Act, for which your lordship was directed to serve a notice to the informant.
Yeah.
The notice has been given. Now they want to engage a legal aid counsel. They are sending the wakalatnama. Can I pray for Friday?
All right. The Learning Council for the state submits that since the offense is one under the offense is one under section 3(2)B of the SC/ST UA Act, the notice of the appeal memo has been on this appeal has been served on the informant, and the informant is interested to uh, oppose the bail application through legal aid services by engaging and has requested for engagement of counsel from the High Court legal aid panel list. And she seeks some time to obtain the wakalatnama of the informant. Leaves this matter on 15th of December 2025. In the meantime, if wakalatnama is obtained, the same shall be handed over to the Secretary of the High Court Legal Services Authority, who shall engage the counsel for the informant, and the registry shall hand over the criminal appeal memo, the interim applications, including the impugned judgment, to the Learning Council for the informant. And the matter will be listed. The name of the Learning Council engaged for the informant be reflected in the short list. Yes.
Item 23.
That reason as to order the wakalatnama executed by the receipt.
The Learning Council for the state has produced the wakalatnama of the informant. Let the same be sent to the secretary so and so for engagement of a counsel, and baki jo the appeal memo so and so shall also be handed over. Yes. Matter will be stated on 15th of December 2025. The name of the Learning Council for the informant shall be reflected in the court.
Appeal, appeal is not the admitted man.
Who da?
Is admitted.
Admitted.
Last order मला 4/8/2000 होती.
Just.
Extra copies are.
अच्छा hard admit कर ली matter be placed also for consideration of the interim applications for bail and sterilization of fine. Yes, on 15/12. Next.
Item 24.
May I please your lordship, my lord, IN number 2081 of 2025 for bail and 2082 for stay of relation of fine. My lord, the appellants are in custody since 2/10/2023.
Deposition copies you
Yes,
have read.
my lord. Start.
Is it your first application or rejected earlier?
The first application, my lord.
Okay, what is the offense here?
302, my lord.
Eyewitness there.
My lord, eyewitnesses are there. Before that, my lord, 1 point with my lord.
How many years you are in custody?
My lord, 2/10/2023, more than 2 years, my lord.
Okay. So 302 IPC and other offenses.
My lord.
You face trial.
My lord.
And you are found guilty under section 302 and sentenced to, and also the other offenses.
Life.
Okay. So who is the eyewitness?
Eyewitnesses are PW 2, 3, 4, 5, and 7.
3, 4, 5, and 7.
Who have turned hostile, my lord. They are the independent eyewitnesses.
Okay. Who has supported this?
Supported, my lord, informant PW 10, 11, 12, and 13.
10, 11, 12, and 13.
My lord.
They have supported.
My lord. And
who is the doctor who conducted the
Doctor, my lord, PW 24.
And PW 10.
My lord, PW 10 and 15. The witnesses to be also recovery. They have also turned hostile. My lord, PW 10.
You said that 10 has supported the prosecution case.
My lord, 10 is 10.
10 is an eyewitness to the occurrence.
My lord, informant.
अरे सपोर्ट कला ना नहीं हमको
आगे आगे आगे
पढ़ियो से तो कोई पढ़ियो को please come to PW10
Alert. I am the informant.
Second paragraph reading.
Alert. Prior to the incident, there was civil dispute in between me and the accused persons. On that day, while I was in front of my house, the present accused persons, along with others, namely Santosh Barik, Jitu Barik, and Litu Barik, but these persons have not even been charge sheeted.
Read it.
Came being with armed with thanga and body and started inflicting assault upon me, for which I sustained bleeding injury on my head, hand, and leg. When my son Vigyan Barik came outside house, all the persons as named above also inflicted assault on him by means of thangavadi, for which he sustained bleeding injuries on his head, legs, and other parts of body. Myself and my son were shifted to both medical through ambulance, being called by Dr. Revati Barik. The above person also did not allow the ambulance to proceed to medical and also put stroke upon the ambulance by the weapon of offense held by them. We both were referred by medical officer both to Bhimsar Bulla for better treatment. After less of 4 days during treatment, my son died. Thereafter, I came to both PS and lodged FIR against the accused persons. This is the said FIR which is marked as executive private.
so what is your submission and
But
the doctor PW24 has noticed number of injuries as it appears on parietal region, chest, knee, other parts of the body, internal injury also he has noticed left fibula fracture and he has opined the cause of death was due to craniocerebral injury caused by blunt trauma, homicidal in nature. All the injuries are antemortem in nature. So, getting corroboration from the medical evidence. What is your submission?
If your lordship may say, even the learned trial court has stated these are the exaggerated versions, but the occurrence took place on 26/9/2023, my lord. But the FIR was lost on 30/9/2023. And the my lord informant state
Deceased was the son of the informant.
Son of the informant.
He was under treatment and he dies 2 days after. Might be that the informant was busy in looking after the treatment.
Informant is also injured.
Informant is also injured.
My lord, even they were shifted to both hospital initially, my lord. Even
it's all right. Those are the matters which is to be taken into account at the stage of appeal hearing. But we are when you are in just for 2 years now, and this type of injuries you have caused and which is getting corroboration from PW24, the doctor who conducted PM, why bail will be granted to you?
And when it is Santosh Barik, Jitu Barik, Litu Barik, all these names, they have not even charge sheeted below.
That's a different matter. They have not been charge sheeted. We do not know whether any application was filed under 319 CRPC to add those persons as accused.
No, it was not filed by the prosecution.
But
and the IO has stated this attack to the ambulance part is not true. It was not even.
Let's leave it.
No, don't go to so nitty-gritty.
This matter in February 2026. The rest of the matter day after tomorrow.